current rates. As you are aware, the Commission has been focused on streamlining our proceedings to make them more administratively efficient. In order number 22446, the Commission determined that an evidentiary hearing should be convened to resolve material issues of fact in dispute for 9 issues. The evidentiary hearing will focus on those 9 issues. In a further effort to streamline the hearing, the Commission directed the parties to file A list of party stipulations, B, the number of witnesses as well as the nature of their testimony in a joint witness cross-examination matrix, C, admissions, and D, a list of authenticated documents. In order number 22696, the Commission admitted into the record the pre-filed conformed testimony of the parties. The Commission also determined that there is no need to lay a foundation and authenticate exhibits on pre-filed cross-examination lists. We have a few housekeeping items at this time. Please be sure to turn off all cell phones. Additionally, witnesses on the bridge, please mute yourselves until you are ready to testify. The parties have indicated and designated time needed to cross-examine the witnesses, and I intend to hold the parties to their represented time limits. At this time, I'm going to ask the parties if they would identify themselves for the record, starting with Washington Gas Light, then the People's Counsel, and then the interveners in alphabetical order.
Thank you, and good morning, Mr. Chairman. John Dodge, appearing on behalf of Washington Gas Light Company. We pre-filed notices of appearance for our legal team on August 5th, 2024, and we made a special appearance filing on behalf of Post and Shell, our outside counsel, on November 12th, 2024. I'm pleased to introduce my colleague, Garrett Lent from Post and Shell, who will be our first chair today.
Thank you.
Good morning, Commissioners.
A little bit. Just you can bring it all the way up to you. There you go. Yes.
The Honorable Chairman Thompson, Honorable Commissioners Beverly and Trabue, good morning. I am Eddie Vinny. The District's Office of the People's Counsel. Appearing with me this morning are Kintasia Scott, Assistant People's Counsel, Evita Modi, Angeline Diamond, DWGPPC, Scott Strauss and Amanda Drennan, Spiegel and McDermott LLP, Kevin Conoscenti, Carden English LLP.
Thank you.
Could you move that microphone closer to you? Because when we get into this, I'm not going to really be able to hear what you have to say.
Good morning, Commission. I am Fran Francis, appearing on behalf of the Apartment and Office Building Association. I'm the only attorney appearing today.
Thank you.
Good morning, Commission. My name is Shilpa Sadasvam. I'm appearing on behalf of the District of Columbia Government, and I'll also be joined by Senior Assistant Attorney General Brian Caldwell.
Good morning, Chairman and Commissioners. Timothy R. Oberleiten of Earth Justice, representing Sierra Club. It'll just be meeting today. Thanks.
Okay. I would ask that when people speak into the microphone, just make sure you speak loud so that we can all hear. So thank you. This being a formal evidentiary hearing, I'm advising parties that pursuant to section 134.1 of the Commission's Rules of Practice and Procedure, the federal rules of evidence will be applied for this hearing with regard to the submission of evidence. Because there may be some discussion regarding confidential information, the parties need to advise the bench when they propose to discuss any confidential information, so I can ensure that only persons who have signed the appropriate confidentiality agreement are present. When we go into confidential session, we will pause the live stream and only permit access to the hearing to those authorized parties. And we will provide an approximate time for which others may be granted access. At this hearing, cross-examination shall be conducted in the following order: WGL's witnesses, then OPC's witnesses. The party that submitted the material issue of fact and dispute shall cross-examine the witness first, followed by other parties in alphabetical order. The Commission reminds and stresses to the parties that their cross-examination must be related to the material issues of fact and dispute identified in order number 22446. Are there any questions or preliminary matters to discuss before the hearing begins, such as availability of witnesses, last-minute scheduling issues, or whether any party anticipates raising an objection or making a motion once the evidentiary hearing starts?
Mr. Chairman, Garrett Lind on behalf of Washington Gas Light. I do at this point want to raise the issue that to the extent parties will go outside the boundaries of the issues that have been specifically set for this hearing in order number 22446, that I will have an objection for purposes of scope. I'm prepared to either present that objection in full now for the purposes of efficiency and renew it at appropriate times if and as necessary, or I can do that throughout the course of the hearing as it becomes necessary. I'm happy to proceed either way, understanding we do have a need to keep this moving.
You can present that now as a matter of efficiency, and if it comes up, you can just renew it later.
Certainly, Chairman. And specific to this objection, Washington Gas is objecting to any questioning that goes outside of the scope of issues that this commission has specifically set for hearing in order number 22446. Those questions and any information sought by those questions will be outside the scope of this proceeding and irrelevant. Specific to Federal Rules of Evidence 401 and 402, evidence must be relevant and it must be within the scope of matters that have been set as material issues for this proceeding. And the evidence presented or sought to be elicited in testimony must tend to make a fact of consequence in determining the commission's actions in this matter more or less probable. Because order number 22446 has clearly set forth the 9 issues that you had flagged in this proceeding, questions on matters unrelated to those issues have no probative value with respect to the issues set for hearing here. I would also just simply note, Chairman and Commissioners, that limitation of scope is also clearly permissible under DCMR 15134.3, which does allow your honors to limit the scope of cross-examination of any witness. And in addition, it's consistent with case law that this commission has cited in a number of orders with respect to the efficiency of these hearings. I would lastly note, Your Honor, that to the extent, in addition to this scope limitation, the core issues to be determined in this proceeding are, number one, a revenue requirement for Washington Gas Light Company, as well as the design of rates for Washington Gas Light Company to recover the authorized revenue requirement from ratepayers in the district. To the extent that counsel is asking about information that is not probative of the costs included in the company's proposed revenue requirement, that information will be irrelevant and admissible. To the extent that counsel is asking about information that is not probative of one of the inputs into the company's revenue requirement, that information is also irrelevant and inadmissible. And finally, if the counsel is asking about information that does not bear upon the design of the company's rates proposed in this matter, that information is similarly irrelevant and inadmissible. I would further just note, Your Honors, you have directed the parties in prior orders to this proceeding, as well as here today, to be efficient with their cross-examination and to keep issues within the scope of what has been set for this matter. With that, I just note that I will renew this objection if and as necessary throughout the course of the hearing. To the extent that I do so, I will refer back to this argument again for the sake of efficiency. Thank you, Your Honors.
Thank you. Any other preliminary matters?
Your Honors.
Your Honor.
Oh, sorry. This is Bhavita Modi on behalf of OPC. I just want to briefly respond that when the objection is renewed to the extent necessary, OPC would like to reserve the right to respond to that objection. And, if necessary, follow up depending on the outcome of that. But for now, we will just maintain that position.
Thank you.
AO's position is the same as OPC in terms of responding. However, I'm somewhat confused by counsel's remarks because he seemed to add together 2 different objections. The first objection seemed to be going outside of the 9 issues that the commission has delineated in the order that it wants to hear today, but he sort of added he's kind of added into that a question outside of that is irrelevant to the commission's determinations in this proceeding. Those are two very different things. What we argue in brief can be vastly more expansive than what the order provides for us to ask cross-examination on. So I'm not sure exactly what he is objecting to, or he has two objections. One going outside of the 9 questions and another objection going to relevancy of information that will help this commission write their final order in this case.
Thank you, Ms. Francis. The commission is aware of the 2 different arguments that were made there, and we will, when it comes time to make a decision, make it appropriately. But thank you for flagging that. Any other Thank you. Any other initial preliminary matters?
Your Honor, can you hear me? Larissa Sepulveda on the line.
Yes.
I'm appearing on behalf of GSA. I'm a senior regulatory affairs program manager, and GSA is participating in without counsel, and I'm here to listen.
Thank you very much.
Thank you.
Okay. In order number 22696, the commission waived opening and closing statements of the hearing as requested by the parties. So we will proceed directly to cross-examination. And WGL, you may call your first witness. Thank you.
Thank you, Chairman. At this time, James D. Stephy is prepared to take the stand and is available for cross-examination.
Aoba, you may begin.
Good morning, Mr. Stephy. For the record, I'm Fran Francis, appearing on behalf of the Apartment and Office Building Association. I'm going to start by asking you to please return to page 14 of your rebuttal testimony.
The rebuttal for page 14?
Yes, please. Are you there?
Yes, I am.
Now, at lines 10 through 11 on page 14, you submit that your rebuttal testimony will provide the company's perspective on the value of the company's affiliate relationships to Washington Gas customers. Is that correct?
What I say is on lines 8 through 11, for the reasons articulated by Washington Gas witnesses Gibson, Block, Quinham, and Aaronbrook, my testimony will provide the company's.
I'm sorry, Mr. Stephy, could you speak up a little bit or speak into
Can
the
you hear
mic?
me?
I didn't
I don't
hear
know if
you.
I can- A little closer, sorry. I said on lines 8 through 11, For the reasons articulated by Washington Gas witnesses Gibson, Block, Quenham, and Banbrook in my testimony, I will provide the company's perspective on the value of these relationships to Washington Gas customers.
In the discussion that starts at page 14 on line 12, you assert that the use of shared services for utilities, quote, is critical to the efficient and effective management of the business, end quote. Do you see that?
On line 16,
Starts on page 14, line 12.
I see the question on starting 12 through 14 and then, right, and then I guess.
Look under that where it says the corporate use of shared services for utilities is not only common, but is critical to the efficient and effective management of the business. Do you see that?
On lines 15 and 16 is what I'm looking at, yeah.
Is your reference to the business in that sentence limited to Washington Gas's utility operations, or is it a broader reference that would include Washington Gas parent companies, ALL, ASUS, WGL Holdings, and/or the affiliates, regulated and unregulated, to which Washington Gas provides services?
Objection, compound.
Overruled.
The business of Washington Gas.
Washington Gas, the utility.
The business of Washington Gas.
Only Washington Gas, the utility?
The business of Washington Gas.
You specifically referring to Washington Gas Light Company, the distribution utility, who has filed for a rate increase in this proceeding?
I'm specifically discussing the business of Washington Gas.
Mr. Steffes, did you understand my question?
Objection, argumentative.
Ms. Steffi, can you answer the question that was asked to you, please?
I'm referring to the business of Washington Gas Light, including all the components of Washington Gas Light.
Excuse me, so that's yes, you're saying you're referring to Washington Gas, the utility?
I'm
In
referring
response to her question, is that yes or no? Yes, you're referring to Washington Gas, the utility.
yes,
Okay,
to the business of
there you go.
Washington Gas Light.
Thank you,
Is that good
Commissioner.
enough?
Thank you.
Okay.
When you suggest that shared services are critical to the efficient and effective management of the business, should that be understood as a representation that Washington Gas Light Company, the utility, the distribution utility, could not obtain the same services without participation in a shared service arrangement that you reference?
Objection as to scope and relevance. This line of questioning is specifically asking the witness to speak about inbound services from Washington Gas's affiliates to Washington Gas, not the issue that was set for hearing, which has to do with the services Washington Gas provides to its affiliates and the charges for those services.
I'm going to allow some latitude here.
Shall I repeat the question, Mr. Steffes?
That would be great.
You see the words that you used on line 17, shared services. You see that?
Do I see shared services on line 17?
Yes.
Yes, I see the word shared services.
When you suggest that shared services are critical to the efficient and effective management of the business, those are your words, are they not?
Which line says critical?
Okay.
What are you?
Let's look together at line 15 of your testimony. You say the corporate use of shared services for utilities is not only common, but is, your words, critical to the efficient and effective management of the business. Do you see that?
Yes.
Okay. Should that be understood as a representation that Washington Gas, the distribution utility, could not obtain the same services without participation in a shared service arrangement that you're discussing here?
As I say on lines 16 through 18, it's sufficient because these important shared services are duplicative across various commonly owned affiliate entities.
But you say it's critical. So could you please address the question that is asked? I'm asking, by using the words critical, should this commission understand that that representation that you are making, that the utility Washington Gas could not obtain these same services without participation in a shared services arrangement that you're discussing here in your testimony?
I just simply say they're critical because it's important shared services are duplicative. You're asking about something else which I don't state.
Would you agree that there are essentially three elements of shared services that witnesses for Washington Gas discuss in this proceeding? The first, services provided by AltaGas Limited, for which costs are allocated or assigned to Washington Gas Light Company. Two, services provided to Washington Gas Light Company by other affiliates such as SEMCO. And three, services that Washington Gas Light Company, the utility, provides to affiliated entities. Is that correct?
Is there a place in my testimony that I can look at for that?
You sponsor several witnesses in these cases, and you list the witnesses in these cases. Do you not at the end of your direct testimony?
You have a page for my direct testimony?
Certainly. Identification of witnesses, pages 25 and 26, your
Yes.
direct testimony.
Yes, I identify the witness, the company on pages 25.
You have several witnesses that testify on affiliate issues, correct?
Yes, the witness Quinum supports the affiliate cost of service study and presents the cost allocation. Witness Block supports inbound affiliate cost. Patrick Bainbrook affiliate cost, yes.
And are you familiar with those witnesses' testimony? You're the overall witness for the company, correct, in this proceeding?
I'm generally familiar with their testimony.
Okay, so now let's try my question again.
Okay.
Would you agree that there are three elements of shared services that the witnesses that you talk about, witness Bainbrook, if I pronounce that right, witness Quinum, and witness Block, all discuss, correct?
Can you ask that again?
The company discusses affiliate issues that you allude to in your testimony with three witnesses. We just discussed them. Witness Bainbrook, witness Block, and witness Quinum, correct?
Yes.
Okay. Now, on the combination of what those witnesses are discussing, they consist of three elements of shared services. And those three elements are, do you agree, services provided by AltaGas for which the costs are allocated or assigned to Washington Gas, the distribution utility? That's the first one. The second one is services provided to Washington Gas Light Company by other affiliates. And three, services that Washington Gas Light provides to affiliated entities. Is that correct?
Subject to the full, what they say, I generally agree with that statement.
Okay.
But I would again refer, they speak for themselves.
Am I correct that the only affiliate to which Washington Gas, the distribution utility, provides services that is a regulated distribution utility is SEMCO?
Objection as to scope. This is not addressed in this witness's testimony.
Your Honor, I really didn't have that much cross-examination. I do not know why this is taking so long. But all of these issues, I am trying to segregate so we can focus directly on issue 7 as specified by the commission in this order. The commission, they have combined many of these issues, and in the order where we specified issue 7 to discuss, the commission also said that they want exploration of the documentation of cost allocation methodologies, expense records, and billing determinations, and billing calculations that can be proven true or false. The commission also said that we need an examination of allocation manuals, billing methodologies that can only be adequately tested through cost examination of witnesses familiar with the specific cost allocation practices and affiliate pricing structures. This is the overall witness for Washington Gas. He has stated what all of these witnesses will testify to. I'm just trying to break it down so we can focus specifically on issue number 7. Really didn't think these questions would take this long. I asked that I may.
Hold on. Ms. Francis, does this witness sponsor those detailed answers? Or is it one of the other witnesses that will be testifying?
Well, I'm trying to find out, which is what my last question was, just determining in on the witnesses that he's testified to and what they are testifying to. And it seems that he's having a little trouble with that. So I will follow up with those other witnesses as necessary. But this was not a difficult question. He also puts in, which I'm going to get to in a couple of minutes, is his AltaGas charts for 2023 and 2024. Those are his charts. He should be able to answer questions about them with all of the interrelationships between the distribution utility, the couple of parent companies they have, and all of the affiliates. These costs are coming in and going out in all different ways. And I'm just trying to segregate them and figure out what we have in this record and what we don't have in this record.
And so the answer to my question is this witness does sponsor some of the calculations that you referenced.
Does he do mathematical calculations?
But he sponsored the exhibits is what I'm asking.
He sponsored the exhibits in, I'm going to point to, I can do them now, in AOBA cross-examination exhibit that was filed yesterday. He is the sponsor of the witness to the response to AOBA data request questions 3-4 and 3-15, which are those charts with the little writing on them with all of the affiliates. And that's what I'm getting to.
Okay. So you can proceed it.
Okay.
Thank you.
Would you like my question again, Mr. Stephy?
Yes, please. Thank you.
Am I correct that the only affiliate to which Washington Gas provides services that is a regulated distribution utility is SEMCO?
I'm going to renew my objection as to scope here. While counsel has identified specific exhibits that this witness is responsible for, this witness does not sponsor testimony as to the specific services provided and also the supporting documents that she is attempting to inquire about. I would also just note, Your Honors, that on the page referenced by this witness in their direct testimony, page 26, lines 3 through line 7, the documents that she has identified as wanting to test this witness about are clearly sponsored by and testified to by other witnesses that are here today. So I renew my objection to scope. If counsel wants to test these issues, there are different witnesses that are here to testify as to them, subject to objection.
Counsel, if the witness sponsored these exhibits, then AOBA has a right to cross-examine them. If the witness doesn't recall or needs to be refreshed with a recollection as to what's in these exhibits, that's a different question, but she's certainly well within her means to question the witness on an exhibit he sponsored.
I understand that, Your Honor. It is, the line of questioning is assuming that certain of these issues are provided within those corporate org charts. She has a specific question to those exhibits. I do not have an issue with that as to scope. But the more generalized question here as to the specific services provided, there's a different witness that speaks to that.
Well, to the extent that Mr. Stephy has the answer to this question, he can answer. If he doesn't have it, he doesn't have it. Please continue, Ms. Francis.
Can you answer that question, Mr. Stephy?
I don't have the org charts in front of me.
You will in a second, so let's hold
So
on.
I don't have the org charts in front of me.
Okay.
And so my question is, I'm not certain if there is another regulated utility beyond Simco.
Are you able to point me and this commission to the analysis that the company has provided in this proceeding that demonstrates and quantifies the savings that Washington Gas's sharing of services with non-regulated U.S. affiliates other than the parent companies have provided to DC ratepayers during the test year?
Between whom? I couldn't hear you. I'm sorry.
Can you point to the analysis that the company has provided in this proceeding that demonstrates and quantifies the savings that Washington Gas's sharing of services with non-regulated U.S. affiliates other than parent companies have provided for DC ratepayers during the test year?
What I would point the commission to is the testimony of the witnesses I've mentioned earlier in their totality.
So in your response, you're referring to the totality of witnesses, Bayenbrook, Block, and Quenum.
Yes. And Gibson at some level too. Yes. Gibson, who's adopted Dormini's testimony.
But at this time, you are unable to point me to anything in any one of those witnesses' testimony that would respond to that question regarding the savings that Washington Gas's sharing of services with non-regulated U.S. affiliates have provided to DC ratepayers.
Yes.
Now I'm going to ask you to turn to what was passed out last night. Counsel, does he have a copy of ALBA's cross exhibits that were emailed last night?
You may have a copy of the data request response to the extent that cross exhibits were handed out, though we were anticipating copies to be brought into the room.
If you don't have it, I do have extra. Do you have one, Mr. Steffes?
I don't know which one you're referring to, but I'm not.
There's a packet that's labeled AOBA cross-examination exhibits. Do you have that?
No.
See what you have.
Yeah, why don't you guys confirm, make sure we're looking at the same documents. Thank you.
Thanks, John.
Okay, please look at the first document, which is a response, which has been Your Honor, I'm asking the witness to please look at a document which was pre-marked as AOBA Exhibit 34, Washington Gas WGL response to AOBA data request number 3-14. I'd like to have that identified for the record as AOBA Exhibit 34. Just as an aside, we started our exhibit numbers for cross-examination at the number that we left off with when we submitted the day before our list of stipulated exhibits that we wanted in the record but did not have cross for.
Okay. Thank you. So noted.
Do you have a, please take a minute to look at that.
Just basically, it's the org chart for the enterprise. Is that what, I think it's one page, right?
Let's look at the first page in the question. And in the question for 314, we said, please provide an organizational chart for the entirety of operations and holdings of AltaGas and AltaGas US as December 31st, 2023, including all affiliated entities. And then your response, because you're the sponsor of this exhibit, do you see that?
I say see attachment A, attachment ALA structure as of December 23.
Yes, and do you see your name at the end of the page where it says sponsor? Yes?
Yes.
Okay. Now, starting with the AltaGas Limited organizational chart attached to the company's response to AOBA DR 314, am I correct that this chart provides AltaGas's organizational structure as of December 31st, 2023?
To the best of my understanding, yes.
Am I correct that this organizational chart was provided as an attachment to AOBA data request 3-14, and it indicates that Washington Gas Light Company has no subsidiary entities?
I'm having a hard time reading it, to be honest, even with my reading glasses.
Well, let me try to help.
Where on the chart are you recognizing? You have a magnifying glass. If I
Okay.
could use that too.
Okay, well, I need it too, so I'll be happy to share, but I'm going to direct you to the right place.
Yes.
Take a look at the bottom of the chart, all the way to the right on the second-hand column.
All right,
In
okay.
blue, the last one says Washington Gas Light Company of Virginia and DC Corporation. Do you see that?
See, under AltaGas Services, you're under AltaGas Services, then you're coming down through Wrangler. Where do you see that?
Look all the way to the bottom of the page on the right.
Oh, there, okay. Under Wrangler SPE, 100% owning of Washington Gas Light Company of Virginia and DC Corporation.
Okay, now under Washington Gas Light Company, we don't see any subsidiaries under them, do we?
There is nothing on the document to show that there's anything below that entity.
So would you agree that this chart shows that Washington Gas has no subsidiary entities?
I would agree that this chart shows that Washington Gas Light Company, a Virginia and DC corporation, has no entities on this chart.
Would you agree that since the merger of AltaGas and WGL Holdings, there have been numerous changes to the AltaGas organizational chart?
I honestly don't know since the merger. I just don't follow the org chart that closely to know what numerous would be.
Were there any changes to the list of affiliated entities to which Washington Gas Light Company provided services during the 9-month period from April 1st, 2023 through December 31st, 2023, the first 9 months of the test year?
I'm unaware.
Now, I'm going to ask you to look at the next document in your packet, which, Your Honor, I would like to have marked for identification. The document which was pre-marked as AOBA Exhibit 35, which is Washington Gas's response to AOBA Data Request 3-15.
So noted.
I'm going to ask that you look at that. Mr. Steffes, do you have that?
315, yes.
Okay, and again,
For 20th, 2024.
okay, and again, that question asks for you to provide an up-to-date organizational chart for AltaGas and AltaGas US, which includes any and all additions to and/or changes in AltaGas's corporate structure since December 31st, 2023. That was the question, correct?
Well, the question was just provide an updated chart as, and include any additions. And we provided the structure as of November 20th to show what the November 20th activity was.
And you can see your response is you are the sponsor of this exhibit, correct?
Correct.
And this chart was as of November 20th, 2024, correct?
That is correct.
Would you agree that the ALA organizational chart as of November 20th, 2024 includes at least two entities that were not reflected in the December 31st, 2023 organizational chart?
I'm not sure. I don't know which two entities you're referring to. Something I want to highlight. And
Would you agree that in the organizational ALA organizational chart as of November 20th, 2024, there are two entities that were not reflected in the December 31st, 2023 organizational chart? And those are, and they're in the blue boxes, Mr. Steffes, they are WGL Midstream MVP LLC and a firm now called Pipeline Holdings LLC. Do you see that?
I see that below, if I'm just doing a comparison of the two org charts, I do see below WGL Midstream MVP LLC, a Delaware LLC, that there are now two entities. I'm not sure if they sit somewhere else in the December 31. I'd have to go do more research. But I do see that just from a picture, there seems to be 200% below the one I mentioned.
Okay. Can you just try to keep your voice up or
I'm
speak
sorry.
closer into the bar?
Sorry, apologies.
Could you just say the last part of your sentence again? I didn't hear it.
I just said I would agree that below, if comparing the pictures or the organizational structures, there appears to be two new entities below WGL Midstream MVP, which would be WGL MVP Holdings and Pipeline Holdings. I don't know. I have to do more research to know if they fit somewhere else on the organization of the chart of 1231.
Okay. Are there any other differences between the December 31st, 2023 and November 20th, 2024 organizational charts for AltaGas?
Well, again, I haven't gone through the details to walk through each entity, et cetera, so I'm only looking at these pictures. There seems to be one other change underneath Petrogras Holdings, it looks to me that we've also added a company called PLC Transportation Limited.
I'm sorry, say a little louder.
It says it appears as well under Petrogras Holdings, which is to the left of the page. There's another addition called PLC Transportation Ltd, which is to the far left if you see that, Ms.
Okay.
Francis.
Can you tell me when during 2024, the new entities under WGL Midstream MVP and LLC were added?
I don't have that information with me.
Do the new entities added since December 31st, 2023 have service agreements with Washington Gas Light Company, or are they served through other entities that have existing service agreements with Washington Gas Light Company?
I don't have that. I'm sure that if you were to ask that question at any time, we could tell you that information.
Ask that question to who?
Do I have the corporate service agreements? No.
No. Do the new entities added since December 31st, 2023 have service agreements with Washington Gas Light Company, or are they served through other entities that have existing service agreements with Washington Gas Light Company?
I'm not aware of that information.
Is there a witness in this case that would know that information?
I'm not sure if any witness can provide that. Any of the current witnesses in the case that could provide that. Just not sure.
Could you please tell me, what has Washington Gas presented in its filed testimony and exhibits in this case that documents the impact of changes in the AltaGas affiliates on the Washington Gas Light Company's cost of providing affiliate services during the test year?
Can you ask your question again, Miss Francis?
What has Washington Gas presented in its testimony and exhibits in this proceeding that documents the impacts of changes in AltaGas affiliates on the Washington Gas Light Company's cost of providing affiliate services during the test year?
I'm not sure if we addressed that question. I'd have to look at the other witnesses to know if, again, if there's a service agreement added, it would be included in the accounting of that between those parties.
All right. What has Washington Gas presented in its filed testimony and exhibits in this proceeding that documents the impacts of changes in AltaGas affiliates on the Washington Gas Light Company's cost of providing affiliate services during the rate effective period?
I'm not sure.
Now, let's go back to your rebuttal testimony at page 14. At page 14, you suggest, as part of your discussion that starts at line 15, that AOBA witness Timothy Oliver grudgingly admits that, quote, shared services can reduce operating costs for the company. Do you see that?
On line 18 and 19, yes.
Representations regarding AOBA witness Tim Oliver's testimony says shared services can reduce operating costs for the company. Am I correct that nothing in your rebuttal testimony quantifies such cost savings or the impact of such alleged savings on the company's revenue requirement in this case?
Nothing in my testimony quantifies that.
I'm sorry, could you please repeat that?
Nothing in my testimony quantifies that.
Do I understand correctly that Washington Gas represents that it can obtain shared services from its parent companies, AltaGas and ASUS, at lower cost than the company could achieve if the same services were provided within Washington Gas Light Company?
Objection as to scope. I'm going to renew my prior objection here with respect to the issue set for hearing. That is with regard to the services that Washington Gas provides to its affiliates, not the services that affiliates provide to Washington Gas.
Your Honor, as we can see from these charts, that there's a lot going on within these affiliates, between companies, between Washington Gas. A lot of costs are moving around. We're trying to target where those costs are. Can we target those costs? And can we, importantly, verify those costs? So the witness referred to three witnesses. I can follow up with some of them, but is this the overall representation of Washington Gas through its first main witness in this case, that it can obtain these shared services from its parent, AltaGas and ASUS, at a lower cost than they could achieve if the same services were provided by the utility?
If Ms. Steffies can answer.
Sure. I mean, what I would say is on line 20 through 23, what I would say is these certain business functions are vital to be managed in a way that assures accurate and timely information. And our cost allocation looks and we do look at that. So yes.
Can you identify for me any studies that the company has presented in its filed testimony and exhibits in this proceeding that quantifies the cost and benefits of the services Washington Gas received from affiliates during the test year for this case?
Are you referring about costs coming from AltaGas companies to Washington Gas Light?
That quantify the cost and benefits of the services Washington Gas received from affiliates during the test year?
I would renew my objection as to scope here, Your Honor.
Your Honor, he can point me to the witness if he can't answer the question. Have you presented anything in the testimony? You're the one that discusses the three witnesses that talk about these affiliate issues. If you can't point me to any quantification of the cost, can you point me to the witness that does quantify the costs?
Quantify the cost. I think I would refer you back to witness Block, with witness Barronbrook and witness Gibson.
So you can't specifically identify those studies, correct?
I would refer you back to the testimony of those three witnesses.
Your Honor, I just have a moment. I think I just have one more question. Actually, first I'm going to ask you, before I get to my last question, if you could take a look at the exhibit, the cross-examination exhibits. One that is pre-marked as Exhibit AOBA-36. That's WGL response to OPC data request 4-2. Do you see that?
I have, so,
Should be the third document in your packet.
got messed up the pages, apologies. I have, AOB Exhibit 36, page 105. Is that what you're referring to?
Yes.
It's
And
question number 42.
correct.
See,
As you can see, you are one of the co-sponsors. James D. Steffes, you see that?
yeah, yes, I co-sponsored this with Eric Bach, yes.
Is the response to this data request still true and accurate?
There's a lot here, but I'll just go through. Provide, in the answer, links to copies of the shared service agreements between Washington Gas and the following entities for the period 2019 to 2024, all of which are approved, are listed below. So are that at the time of this answer on 11/15, I would have think those are true. Point B, there's a lot here. You're asking me that everything is. As far as I know, this is all correct as of the time. I have no reason to doubt otherwise.
Mr. Steffes, am I correct that most, if not all of the savings from shared services that Washington Gas claims in this case emanate from the services that Alta Gas provides to Washington Gas? And nowhere has the company provided an assessment of the cost savings, if there are any, that Washington Gas achieves through its provision of services to unregulated affiliates such as Petrogas Pacific, Bryce Energy, or IXL Propane.
I think there's a number of questions in that. Maybe break them apart.
Sure, let's break it down.
There's quite a few.
Am I correct that most, if not all of the savings from shared services that Washington Gas is claiming in this proceeding emanate from the services that Alta Gas provides to Washington Gas?
Nowhere in my testimony to talk about the specific number. I'm assuming other witnesses would have most, if not. I don't want to hazard a guess on most. I think in other witnesses' testimony, I'm sure they have numbers related to that.
Who would be the other witness?
The same witnesses that I've referred to before.
And would you agree that nowhere has Washington Gas provided an assessment of the cost savings that Washington Gas achieves through its provision of services to unregulated affiliates, as an example, such as Petrogas Pacific, Bryce Energy, or IXL Propane?
An assessment of the saving, can you, again, I'm Trying to make sure I understand your question. Assessment of the savings for what? To which entity?
That Washington Gas achieves through its providing services to unregulated affiliates.
I'm not aware of that, no.
That concludes my cross for witness Stephy's. I would like to move into evidence 3 AOBA cross-examination exhibits, AOBA Exhibit 34, 35, and 36 into evidence. However, I do note that AOBA Exhibit 36, along with Mr. Steffi's as the sponsor, as I believe it's witness Eric Block. I would like to move it in now, but if necessary, I will also ask Mr. Block, witness Block, to verify that exhibit unless there's no objection from Washington Gas admitting it now.
No objection to the omission of those 3 exhibits.
So moved. Thank you.
Thank you, Your Honor. And I want them all identified, admitted as the exhibits that they were identified as, AOBA Exhibits 34, 35, and 36. Thank you.
Thank you. Sierra Club through Earth Justice.
Thank you. Thank you, Chairman Thompson, Commissioners. And for the record, again, Tim Oberlein on behalf of, with Earth Justice on behalf of Sierra Club. Good morning, Mr. Steffes. How are you?
Well, thank you. How are you?
Great. I have a number of questions for you this morning. Just want to confirm, at Washington Gas, you are the Senior VP for Regulatory and Public Policy, correct?
Yes, and to this point, I also have energy acquisition, but yes.
I'm sorry, what was that last?
I also have the energy acquisition at this point, if you're asking my current role.
Okay, thank you. And in your testimony, you state that on behalf of the company, you quote, lead our government affairs, public policy, rates, and regulatory affairs efforts, correct?
Where is this in my direct?
Should be in your direct. At the beginning, I will pull it up. Direct you to page 1,
Page 1.
lines 6 through 11. You state 8, starting at 8, in this capacity, I lead our government affairs, public policy, rates, and regulatory affairs efforts.
Right, and then and I also lead our energy acquisition team. So
Can you describe a little bit what that means in terms of what your role is at WGL?
I help lead and coordinate our government affairs, our public policy conversations, and then regulatory activities and rate activities. And I also help ensure that we have adequate natural gas supplies for our customers with a team of people that buy gas for our firm customers.
And are there employees at WGL that work in your department?
Yes. Yes.
How many of them are there?
I'd have to, I honestly don't know the exact number right now, but more than 5.
Are they broken down into the different areas that are listed here? Government affairs, public policy, rates and regulatory affairs? Are those delineations of branches of your department?
And energy acquisition, yes, that's sort of the general framing or general categories.
Okay. Can you describe the difference between government affairs and public policy functions at WGL?
Our public policy is analysis and policy and does a lot of work with regulatory affairs. Government affairs is engagement with community and government actors.
So you do engage with the public at large and community members and community leaders through the government affairs function, correct?
Different people of my team do, yes.
Okay. Do you have an idea of the number of employees that work in the government affairs function?
Today,
WGL?
um, in the government affairs function,
Yes,
6.
6. Are any of them registered lobbyists in DC?
I'd have to check that. I'm not sure if they're rich, but yes, I'm assuming they are.
Okay.
If they need to be.
Okay. Mr. Chairman, I'm going to approach the witness with what was pre-marked as Exhibit SC 2027, which is WGL's compelled response to our follow-up DR 217.
Okay.
How may I approach?
Has WGL had the opportunity to review this document? You're fine with it? Okay.
Thank you.
Mhm.
Mr. Steffes, as I stated, this is a copy of a response to Sierra Club's follow-up DR 2-17. If you turn to the second page, it indicates that you sponsored this response at the bottom, correct?
This is page 2 of 3,
Yes,
SC
2 of 3, sir.
27? Is that what you're asking about?
Yes. Did you sponsor this exhibit?
Yes.
And just indicating that on page 3, again, you sponsored the response to the follow-up to 216 and 217 specifically. Is that correct?
On page 3, I also sponsored that, yes.
And you see in the top, in the beginning of the response where it indicates Washington Gas does not have any record of lobbying costs not appropriately included in FERC USOA account 426.4. Did I read that correctly?
Washington Gas does not have any record of lobbying costs not appropriately included in FERC USOA account 426.4.
Okay. And in there, you go on to describe a couple of the functions under the government affairs function at WGL. I just want to ask you a little bit about those. You'd spoken earlier about your definition of government affairs. Just want to ask you, are you aware with the nonprofit Public Affairs Council?
I'm not sure if I'm aware. No, I don't. If I am aware, I'm not. It's not.
Are you a member of any organization that convenes the public policy community or government affairs community?
Can you? I'm not sure if I'm honestly, I'm not sure what you're asking me.
Sure. Well, a number
Like,
of,
give me an example of specifically the entity am I a member of? And I would say yes or no if I could.
okay. A number of professional, I'll represent to you that a number of professionals in different fields are representative of affinity organizations that promote the interests of that group, bar associations, for example, for attorneys. You are a public policy and government affairs professional, correct?
Yes.
Are you a member of any organization that convenes you and other public policy or government affairs professionals?
No, I mean, I don't believe I am.
Okay, fair enough. So I represent to you that the Public Affairs Council defines government relations as government relations or government affairs as a broad range of strategies designed to influence public policy, including lobbying, policy communication, political action, committee management, grassroots and issues managements. Does your role include influencing public policy?
Yes.
And what does that entail?
It entails influencing public policy.
What exact activities do you engage in to influence public policy?
Providing facts to people so that they can help make good policy for the communities we operate in.
Do you do more than provide facts? Do you advocate on behalf of ratepayers or the shareholders of Washington Gas?
Can you define advocate?
Advocate as in promote a position that would be beneficial for ratepayers or for shareholders of AltaGas?
If you consider this rate case, I am advocating for fair and reasonable rates for our business so we can provide safe and affordable And reliable energy, yes.
Aside from so would that fall under the regulatory affairs bucket of activities we discussed?
Yes.
But under government affairs, which might include lobbying, is there other activities that, or other advocacy that you or the people in your department engage in to promote better outcomes for ratepayers or the company?
I mean, the instance for me, I'm on the DC Chamber of Commerce, and I do engage broadly with the DC Chamber to make sure DC is a productive place for people to live and work. So I do promote and hope that DC does well for both our company, but for everyone that lives and comes here.
So through the Chamber of Commerce or in other venues in which you engage in advocacy on behalf of Washington Gas, would you say that, is it fair to say that it is part of your role to advance outcomes for Washington Gas that benefit shareholders of its parent company, AltaGas?
Yes.
And does that include discussions, meeting, or interactions with publicly elected officials or their staff?
I meet with public officials and staff members. I have met with public officials and staff members.
Okay.
Across the jurisdiction,
Okay.
both elected and non-elected.
Are you aware of the FERC definition of lobbying or activities that fall under the USOA account 426.4?
Yes, I am. I'm looking to see, I think somewhere in one of my DRs I did put that, but I'm not sure if I can find that. Here it is. In a DR I provided 216 to you, or 26.4 expenditures for certain civic, political, and related activities. And goes on from there.
Okay.
Definition.
And that definition includes expenditures for influencing public opinion with respect to legislation, possible adoption of new legislation, or repeal or modification of existing legislation or ordinances, correct?
That it reads, yes, either with respect to the possible adoption of new referenda legislation or ordinance, or repeal or modification of existing referenda legislation or ordinances.
So there's costs that are recorded in FERC USOA account 426.4 by WGL that go towards those efforts, correct?
Yes.
So there would be efforts by Washington Gas to advocate for the repeal of legislation or ordinances that would be recorded in this account, correct?
If it falls on the definition, they would be recorded in 426.4.
Are you aware of any specific costs that are recorded in that account for the repeal or modification of ordinances or laws in the district?
There are costs, as we've filed, related, and so certain government affairs costs are included outside of that, and then there are costs that are in 426.4.
So trying to understand what you just said, there are costs that are separately deemed government affairs and others that would not be included in 426.4?
Well, government affairs costs wouldn't be in 426.4, they would be, but lobbying costs would be. But I would have to know what time frame, what time are you asking, or costs, specifically what you're.
Yeah. Okay, no, I'm just trying to get a general background, and I'm going to get to those questions shortly. But what you're saying now is that despite the definition of government affairs, including lobbying, for WGL's purposes, they are considered two different functions, government affairs versus lobbying.
Yes.
But there are lobbying efforts that occur at WGL from government affairs employees.
Yes.
So I was looking at your profile, and on the company's website, it states you're responsible for establishing, communicating, and executing on the company's multi-state government relations and regulatory priorities across Washington, D.C., Maryland, and Virginia. Does that accurately portray the scope of your role across the DMV?
Yes.
Are there government affairs or lobbying efforts that are done by your office that are not specific to one jurisdiction, but according to this description, cover general policy across the service territory?
It was a compound question.
Okay.
There are government affairs activities that do cross the jurisdiction. We are strongly supportive of the DMV at whole, and so there are times when we engage to help make the DMV a better place. Specific to lobbying, though, it would be related to a specific piece of legislation in the jurisdiction. There are, and then I guess the other one would be federal, but I'd have to look to see.
Mr. Chairman, I'm going to approach the witness with what was pre-marked as Exhibit SC20, that's Sierra Club 20, the response, WGL's response to Sierra Club Data Request 2-16. Everyone should have a copy of that.
We have a copy of that, Your Honor.
Please proceed.
Mr. Steffes, I'm sorry I keep approaching. Do you have a copy of all of these DRs already?
I have a copy of some of your DRs.
Okay,
James.
then I'll keep approaching you with these so
I'm not sure if I have all of them, but some of them.
we'll save some time on page flipping through your index. So looking here, this is your response to Sierra Club Data Request 2-16, correct? Page 3, you sponsored this response?
So this has on 529 a motion to compel response by me. Yes. Can you hear me? I'm away from the microphone. Sorry.
No, I got you. And we'd ask some questions about the company's budget for lobbying activities, regulatory advocacy, and public opinion research. I want to go to your response, sub A, sub B, and sub C on page 3 of 3. Specifically sub B, where you indicate that the amounts reflected in account 426.4 are not budgeted such there is a separate DC budget because the costs are not included in rates and not subject to jurisdictional rate treatment. Is that correct?
On B, I say that the amounts reflected in account 4264 are not budgeted such there is a separate DC budget because the costs are not included in rates and not subject to jurisdictional rate treatment.
So this account contains expenses across WGL service territory for government affairs and lobbying.
Count 426 is for expenditures related to as the definition said back on A, related to the 426, the FERC USOA account expenditures.
For those list of activities that are usually recorded in 426.4A, right?
That is correct.
And they're not, what this means essentially, you don't disaggregate for specific work in jurisdictions. It's all just one number of spending and costs by the government affairs office at WGL, correct?
I have a budget for, yes, for government affairs.
Okay. And again, just confirming that this covers a range of activity for WGL to persuade opinion or repeal legislation, as you stated before, correct?
What's this? I didn't know specifically. This is what?
The amounts that are recorded in 426.4.
The amounts recorded in 426.4 is related to, as the definition states.
Okay. Are you familiar with how WGL and other gas utilities, gas distribution utilities record and report these costs to FERC?
Objection compound and also calls for speculation as to the activities of other natural gas utilities.
I'll rephrase.
Thank
Are you aware of how WGL reports on what is in or what is recorded in 426.4
To FERC?
to FERC, to the commission?
I don't know how to report that to FERC. I don't know the FERC reporting process.
Mr. Chairman, I have an exhibit that I want to mark as Sierra Club 31. It is WGL's April 2nd, 2025 filing with the commission, including its annual report on FERC Form Number 2 for the calendar year ending in 2024. I have copies. We're not previously provided, but I have copies here to provide.
Without having seen this exhibit, Your Honor, I'm going to object to the provision of it to this witness. To the extent that this was a cross-examination exhibit, it should have been designated and previously identified as such by counsel. In addition, this is an exhibit that, to the extent the counsel wants to move it into the record, they will have to lay appropriate foundation because it has not been previously identified by this for this commission.
Your Honor, I would respond that there was no prohibition for us introducing additional exhibits based on us being barred from doing so by not including the original list. This is a publicly filed document with the commission. To that extent, I think it's self-authenticating in terms of it's stamped by the commission as filed and is a public document.
First, I would like for you to share a copy of the document with opposing counsel.
Right.
And then if you can lay the appropriate foundation and if the witness has any familiarity with the contents of it, then I'll allow it. But we ask for pre-filed documents to try and avoid these types of situations.
Fair enough, Your Honor. Thank you. I have another copy for the witness, Your Honor, if I may approach.
Yes. And do you have a copy for the bench as well?
Give you my copy, Mr. Chairman.
Thank you.
I just need to pull it up now, Mr. Chairman. My fault. Apologies, Mr. Chairman, just one more minute. Approach the witness, Your Honor.
Yes.
Want me to look at this one? Okay. All right.
Okay. Okay. I have before you is, as I mentioned before, WGL's filing before the DC Public Service Commission dated April 2nd, 2025, titled Washington Gas Light Company's Public Annual Report on FERC Form Number 2 for the calendar year ended in 2024. Do you recognize this document?
I don't, I mean,
Don't?
no, I don't know that. I see that John Dodge filed this at, with the commission, but I do not, I mean, I recognize it as a FERC Form 2, but I don't know that I know this document specifically.
Do you ever provide any information for reporting to FERC or the commission?
Do
To-
I provide
To
information?
to Mr. Dodge or other attorneys in their filings?
I'm sure if he asked, I will provide information for his filings to the both the DC Commission and to FERC or any regulatory commission with jurisdiction over the company.
Do you specifically recall providing information for the FERC annual filing for 2024?
No, I do not remember providing, if any, information document for the filing to FERC or filing to the PSC. I don't remember providing any information for this.
That's fine. Mr. Chairman, I'm going to move on from this and
Thank you.
continue with our questions. And I appreciate everyone's indulgence for the time on that one. Mr. Steffes, put another exhibit in front of you. This time it's on the list. Mr. Chairman, approach the witness with Exhibit SC21. What was WGL's response to Sierra Club's data request 2-17? Everyone should have a copy of that one.
You have a copy.
Okay. You may approach. And sorry, you said this is SC21?
Sierra Club Exhibit 21, yes.
Just want to make sure.
Thank you. Choose. $217 is what you're asking about.
Yes, your response to data request 2-17. In your response to this question, asking for the identities of WGL's lobbyists or government affairs employees, you indicate the company has 2 registered lobbyists during the test year. Is that correct?
I responded to this question. The company had 2 registered lobbyists operating the district during the test year.
And can you tell me when the test year dates run? Sorry to test you on that.
This case has been filed quite a while ago. Let me make sure I remember what the test year was. It's somewhere in my testimony. I want to be accurate. The test year consists of the 12-month period from April 1st, 23 to March 31, 24.
Okay. Are you aware of the requirement that lobbyists on behalf of WGL must register with the DC Board of Ethics and Government Accountability, otherwise known as BEGA?
I'm generally aware that if people lobby, they need to be registered in DC.
Are you aware of any other registered lobbyists beyond the two that you indicate in this response during the test year?
Um, in terms of registered company lobbyists, no.
So,
I mean, no.
so it's your position that there were WGL no other registered lobbyists with Bega during the test year?
I mean, subject to check with my materials. I don't have that in front of me, but no company employees that were registered lobbyists beyond the two.
Okay. Commission previously limited the ability to obtain the identity of those lobbyists, but could you describe what those lobbyists' activities were during the test year?
I would have to go back as lobbyists to look if they had lobbying reports and see exactly what they did. I don't remember during that time frame exactly if there was any lobbying or what they lobbied on, unless I were to have conversations.
You mentioned lobbying reports. Are these internal reports within your department on their activities?
The lobbying reports that you mentioned earlier, if there are some.
As in the requirements that they'd have to file with Bega?
If they lobbied, then yeah, they would have to, and if they were registered, yes.
Do you have any internal tracking of the lobbying efforts of the lobbyists at WGL?
We don't have any documentation that says I lobbied this or that.
Do you have documentation as to the time spent on lobbying?
Employees record their time appropriately or as they're required to, related to the work that they're doing.
Turning back to what was marked as SC 27, which is your response to Sierra Club follow-up data request 216 and 17, page 3 of 3.
Which one do you want me to go to?
SC 27.
I don't know what that is.
On the top right, there'll be designations for the exhibits. This one should read Exhibit SC 27 below Sierra Club.
I have them as, so that's Sierra Club 216 or 2, I'm not sure which one you're asking about. I don't know what.
Well, it appears to be a combined response by the company to our follow-up data requests number 216 and 217. But do you have the 3-page exhibit that I handed you earlier, Exhibit SC 27?
Oh, yes, yes, okay. I see Exhibit SC 21, page 1 of 3, yes.
Okay. And you indicate Washington Gas does not have any record of lobbying costs not appropriately included in the FERC account, as you answered earlier.
Yes.
But you also indicate that for the historic test year, the company included in rates $218,775 of allocated costs associated with government affairs labor costs. Is that correct?
Yes, I say for the historic test year, the company included in rates $218,775 of the allocated cost associated with government affairs labor cost.
And is that salaries for government affairs employees at WGL?
It would be the associated labor costs for those government affairs activities.
Are there other costs associated with the government affairs function at WGL beyond labor costs?
Yes.
What are
Yes.
those?
I'd have to look to see exactly, but it would generally be other costs that may come out. Again, versus this labor cost could be some mileage, things like that, I'm assuming.
Fees, expenses.
Some, right. I mean, if somebody had to go to a meeting, I'm assuming that would be in there. Yes.
Okay. So in that, Sierra Club had asked WGL for a totality of its costs and budgets related to lobbying and government affairs. And you only responded with the salaries of government affairs employees, correct?
Objection compound.
Okay. I'll break it down. So Sierra Club had asked for a number of costs associated with lobbying and government affairs. The response here indicates, as you mentioned, only 218,775 of allocated costs associated with government affairs labor, correct?
My response during the test year included the cost, allocated costs related to government affairs labor costs. Yes.
Okay. And as we discussed before, government affairs the function of government affairs at WGL could include lobbying. Is it fair to say that these labor costs include lobbying labor costs?
No,
Why is that?
because those costs would be recorded in 426.4.
Are there employees that are specifically employed for lobbying as opposed to government affairs functions at WGL?
No,
So there would be an employee in the government affairs office at WGL that engages in lobbying, is that correct?
may engage in lobbying. Yes.
May engage in lobbying. And if they do so those employees' labor costs were included in rates in this case, as you indicate here, correct?
For the government affairs allocated labor costs
Okay, for those employees who may or may not have engaged in lobbying.
during the test year.
Objection. That assumes a fact, not an evidence. The witness has been clear that these are government affairs labor costs. Counsel tried to ask this question and called them lobbying costs as well. Witness has drawn the distinction. It's improper to assume that these are the same thing.
The court's recollection, or the commission's recollection will control.
Pardon me if you answered this before, but can you explain why WGL does not track lobbying costs outside the FERC USOA account 426.4?
Objection asked and answered. We've gone over this a number of times at this point.
Mr. Chairman, this is opening up a specific new line of questioning. I mean, I cannot recall if witnesses specifically answered this, but it could be quickly disposed with a quick answer.
Brief answer, please.
I'm not even sure what the question was.
Can you explain why Washington Gas does not track lobbying costs outside the FERC USOA account 426.4?
Lobbying costs are recorded in FERC USO account 426.4. And this account is not included in utility net operating income.
So you don't keep track of it outside of that account because you do not.
Lobbying costs are recorded in FERC USOA 426.4.
So you don't keep track of them outside of that account because it's your position that they are not included in rates.
Lobbying costs are recorded in account FERC USOA 4.6.
Please move on, counsel. This has been asked and answered several times.
Thank you. Mr. Steffes, we talked before about, as you mentioned here, what is included in activities that are tracked in 426.4. Are you aware of specific efforts by the government affairs department at WGL for advocacy regarding the DC Clean Energy DC Omnibus Amendment Act of 2018?
Am I aware of specific, what was?
Activities or advocacy around that DC
Around
law?
which piece of law?
DC Clean Energy, the Clean Energy DC Omnibus Amendment Act of 2018.
2018? No, I don't know what happened with WGL in 2018. I wasn't an employee at the time.
Are you aware of Clean Energy DC Omnibus Amendment Act of 2018 and what it requires?
Do you have specific, like, if I wanted to go look at the statute, I'd be happy to talk about it if you have a reference to the statute.
I think you testified earlier that as the Senior Vice President for Regulatory Affairs, you generally engage in providing facts or advocacy around public policy. Is that correct?
I try to provide facts to relevant parties.
Sorry, are you finished? I'm sorry, I didn't hear you trailed off at the end. You said you provide facts around
To relevant parties throughout.
relevant
Yeah.
parties. Would that include facts or advocacy in regards to specific legislation in the service territories in which WG operates?
Would it include facts in our service territory?
Facts or advocacy by WGL?
It would include facts. I don't know what you mean by advocacy.
We discussed advocacy before, and I think you agreed that it meant putting forward a position on behalf of WGL in regards to public policy.
I'd go back. I don't remember saying,
So you're not aware of the Clean Energy DC Omnibus Amendment Act of 2018?
no, I'm aware of a number of statutes, but when I discuss statutes, I'd specifically like to refer specific to the language. So if you have a specific piece of that statute, I would be happy to go through it in detail because I don't want to generically say something around a law that I'm not keeping at the top of my head.
Well, that is not my question. I'm just asking you generally. I mean, you are aware of the climate laws in the district, correct?
I'm aware generally, I'm not an attorney, but I am aware generally of a number of laws in the District of Columbia related to climate and energy.
Okay, you may not be an attorney, but as we discussed before, efforts by the Government Affairs Division at WGL do advocate for modification or repeal of legislation, correct?
Government affairs activities engages in government affairs activities.
Are you aware of the Healthy Homes and Residential Electrification Act of 2024?
Again, I'm generally aware, yes.
You're not specifically aware of the requirements of that act?
If I don't keep those at the top of my head, exactly what that statute totally required.
You don't keep at the top of your head the specific climate laws in DC as they relate to WGL's operations?
No, because
Asked and answered.
Please move on, counsel.
Will do. It's going to run through a couple more to see if you are familiar with them. Are you aware of the Climate Commitment Act of 2022?
I'm generally aware.
Are you aware of the Greener Government Buildings Act of 2022?
I'm sorry, I couldn't hear what
Are you aware of the Greener Government Buildings Act of 2022?
I'm generally aware.
And last one, the Clean Energy DC Building Code Amendment Act of 2022.
I guess I'd have to go back specifically to see which one that one was, but yes.
On that one, I'll represent to you, it is a requirement for the no longer installing fossil fuel equipment beginning in 2026 as part of an amendment to the building code. Are you aware of that?
I'll take that as the law that did that. Yes, okay.
And are you aware of the efforts of any of, I'm sorry?
I don't keep the names of all the laws directly in my.
Are you aware of, despite not having a general recollection of these acts, are you aware of employees at WGL in the Government Affairs Division taking any actions on behalf of WGL regarding these pieces of legislation? as in lobbying before.
During what time frame?
During the test year?
During the test year.
This would probably likely be specific to only a few of these.
I'd have to go back and specifically look by piece of legislation and think about, did we do any government affairs work around those during that time?
In the Government Affairs Division at WGL, do you have any internal reporting about advocacy, like as in internal white papers, plans, anything like that?
Objection, scope, and relevance.
Please draw a nexus between this and the material issues of fact and determination, please.
Sure, Mr. Chairman. So this goes to the underlying issue of, I believe it was identified as issue, hold up right here. Issue number 15, whether Washington Gas is using ratepayer funds for legal expenses associated with federal actions to invalidate DC laws. And 16, whether Washington Gas is using ratepayer funds for lobbying efforts in DC and other jurisdictions. It's trying to get a handle on what exactly employees in the Government Affairs Division of WGL or the Affairs Division of WGL in general did in the course of their employment that they were paid for with ratepayer funds, possibly to invalidate DC laws or to lobby in DC. I think understanding what the department does, what the employees did, specifically during the test year, is important to know whether these costs are prudently incurred. And I think that goes to the determination of the issues that the commission set forth here.
If the witness can answer the questions, please proceed.
Again, it's that time frame. What would we do as a government affairs person? We may reach out to other trade associations and discuss for them to help them understand there is a law that's being proposed. So we may meet with the Restaurant Association. We may meet with the builders, we may meet with the chamber. Again, talking to our peers and our stakeholders, our customers, to make sure they're aware of what's going on at City Hall. And that's government affairs.
And you testified earlier that you would provide facts, I guess, to corroborate that statement that you're making these parties aware. But you also had said earlier that you would be providing the company's position. When you do outreach to these trade associations, other groups, the public, do you provide them your, I guess, WGL's take on the situation or WGL's position?
We would provide a fact like that PJM today uses 50% natural gas generally when it runs its grid. So we make sure those facts are understood by customers. So we would provide that kind of fact. And we would provide the fact that this could impact your business. You will have to think about how your business is operating.
So getting back to the question I had about WGL having records of its activities in government affairs, are you saying that there are internal documents that represent or at least record WGL's government affairs activities to these entities, such as presentations that you put together for them or internal policy documents?
I renew my prior objection, scope, and relevance here. We've circled back to this. The nexus has not been drawn.
Mr. Chairman, I just drew the nexus with the discussion with what I represented to the commission. These are exactly the type of documents or type of evidence that would be relevant to the issue because it should underscore whether this amount of funds sought by the company are prudent.
If the witness knows.
During the test year, did we have a document that would say, this is what we would tell the Restaurant Association about something? I don't know that I have that or not. If I haven't been asked, so I'd have to go back and look if there's a specific document. Man, but could it be just an oral presentation or a document? I don't honestly know what we did around that because until this moment, I've not been asked that. But do we have conversations with other associations? Yes.
You have internal meetings to discuss your positions and policies and these type of outreach efforts, correct?
Yes.
Do you take minutes at those meetings?
No, not often. There may be people taking notes, but I don't know I would call them minutes.
Okay, looking here in your response, again, to 216 and 217, you go through a list of activities in the government affairs function. Can you please describe what activities fall under the definition of, quote, customer impact and policy analysis, end quote?
Just as I said, customer impact policy analysis. Hello, restaurant association. If the district bans natural gas, you're going to have to cook on an electric stove.
Does this also relate to residential customers, your outreach?
Hello, I don't know if we've done any outreach directly to residential customers during this, but it would be the same. Hello, residential customer, you can no longer have a gas cooktop.
Can you describe what activities fall under stakeholder engagement?
Okay, objection here, Your Honors. These are re-asks of discovery requests that were attempted to be compelled toward the end of the procedural schedule in this matter. The commission ruled that that information did not have to be provided for discovery. This is an attempt by counsel to get on the stand what they were told they were not allowed to have in discovery.
Your Honor, I think that, I'm sorry.
I was going to say, any response?
Right, I'm gonna disagree with counsel and say that that is not the reading of the order in response to our third motion to compel. I mean, specifically in that order, the commission did bar us from getting certain responses in regards to identification of lobbyists, which I think our questions have shown we've let go of. To the extent that they sound familiar to a DR that was not compelled by the commission, they still get to the relevant issue of understanding exactly what the functions are of the government affairs section of WGL, such that they are either recording labor costs or other costs associated with those functions correctly in the 426.4 account or in other accounts, which as far as we know are at least one with the labor costs for the amount of $218,775. I don't see a tension between what the commission ordered in terms of not responding to or not compelling response to discovery and getting to the fundamental issue that the commission designated for this hearing. That's simply what we're trying to get at. That they use a similar language does not mean we are re-asking this hearing.
I'm inclined to agree with opposing counsel WGL. For a great deal of latitude in this space for you to question the witness on a number of issues. But we have set some limits and parameters around those issues. And so please move on.
All right, Mr. Chairman. Just to understand the parameters of that ruling is that we should not be asking further questions about what activities occur in the government affairs section of WGL?
Well, the order speaks for itself.
Okay. I'll move on then, Mr. Chairman. Okay. Chairman, I'm going to approach the witness with what Sierra Club remarked as Exhibit SC28, which is Washington Gas's revised response to Sierra Club DR 217.
Okay.
Thank you.
We have a copy of that response.
This is a document that was first filed in response to our third motion to compel, in WGL's response to our third motion to compel. And it appears to list certain costs that are being tracked by the company in several accounts. Since you, Mr. Steffes, had sponsored the response to 217, I wanted to ask you a couple questions about this document. Are you familiar with this document?
What I'm looking at? Yeah.
Yes. Okay. Can you tell us a little bit about what this document is representing and what it's recording here?
Cumulative and calls for a narrative.
I'll ask specific questions then, Your Honor. So the first line, where it says 184181, non-productive labor costs. What does that mean?
It means non-productive labor costs.
But what activities are captured under non-productive labor costs?
Labor costs. I'm not an accountant, and so how, this is how the cost is, but it means the labor cost, the non-productive time of labor.
Okay, just to shortcut this a little bit, do you think that there is another witness that would be better poised to answer questions about
It could, there may be another witness to discuss exactly how different things go in there, like the third line, 232, 321, I know is generally the long-term incentive cost for the team, for the government affairs team.
Okay, so you do have
The 232, 312, I think, is the short-term bonus, and the 9,200, I think, is just salaries. So I think all of my time is productive, but the accountants don't.
Okay, so there are certain items on this document that you could provide information, for which you could provide information, correct?
Yes.
Okay.
I asked the accounting team to pull these numbers, or they pulled them on behalf of the legal team.
Okay, so this document was, I think I just heard you say this document was produced at your direction, correct?
Was what?
Produced at your direction?
Produced with the support of counsel.
Okay. Going to the next item, 232312 AP EMP REL bonus accruals. Are you aware of what that is?
I believe that's our short-term bonus, the STI.
The STI, short-term bonus.
I believe,
Okay,
subject to check.
okay. And can you tell us what exactly that is?
The STI
Yes.
is a part of our compensation framework that allows the employees to receive, depending on delivery of certain value drivers and internal metrics,
Okay.
they're a little bit of their annual bonus.
And these are incentives provided to employees for the value drivers that you list in your testimony, correct?
For that and their individual contributions, yes.
Okay. So the short-term incentive pay for employees has two inputs. One, whether they meet the value drivers of the company, and two, whether you had just said their individual inputs on other.
Whether the company meets its value drivers,
Okay.
and then how the employees, of course, have to deliver against,
And the next line for 232321 AP incentive PLN performance unit. Can you tell us a little bit about that?
I believe that subject to check is our long-term bonus. So you can see that's marked as 0 and it's not charged into the rate because LTI has not precedentially been allowed. Although again, LTI, since it asked, is a key part of the compensation. And as most employees would have LTI.
And the last line, admin and general salaries. Do you have any information beyond
I
what?
believe that's the salary activity of the actual salary expense subject to check.
Of the government affairs section?
I think the account is for everyone, but I think this is pulling out for government affairs. I mean, I think we would use that account for everybody, right? The number itself, but yes, for government affairs, that's this number. For the government affairs, the people down below mentioned.
Okay, so for the total amount for government affairs salaries, I'm assuming this is during the test year, is 906,552. correct?
And salaries would include the two below the line numbers, the PAC expense. So the real total, if I understand this data, is 2283439 would be the labor cost, but the PAC expenses are a part of 426. See where it says 426, and the other one is 426. Those are excluded. So people that support our employee PAC can't put that into rates because we don't put that into 426.
Okay. So I'm just trying to understand. I'm trying to understand how the 218,775 for allocated government affairs labor costs is represented here.
Yeah, I would say if you look at this chart, I'll make two adjustments to the chart looking at counsel. There's a mistake on where it says 75, that should be 175. If you look at the 92000 administrative, you have 906,552, the 1936. That's a mistake as we copied that, someone forgot the one. And then the total above the line shouldn't be 47, it should be 247. That's how you add, just to make sure there's a correction I would make. So that's the causal track, if you will.
Sorry, one question for you.
Yes, sure, Mr. Chairman.
Just going back to this, you said that 920,000 should be 175 or 275?
175.
Okay.
And it's just 19.36% of 906,000. And then somehow the 2 in front of the 47 right below that on the summary line was also cut off in the reporting of this. I would update that.
Thank you.
Yeah, and then then you get down to 247, and again, that will tie across to that number. We had earlier filed 218,775, and I'll just adjust that statement. As we looked at this again, an employee that had left the company, somehow that was not appropriately, so it's really 247 when we put her full information back in, and we did this finally, I think on the 4th or 5th time. That's how we get from 218 to 247. There was a gap in the earlier analysis, and I apologize for that.
To proffer here, Your Honor, the company's response to the third motion to compel included this as an attachment that explains the update of this number as well. To the extent that an additional correction would be required to this so that we have an accurate reflection of this exhibit in the record, we're willing to revise that and submit it as an on-the-record data request or as a revised or updated exhibit. Again, the transposition errors here, the witness has explained, but if additional clarity is needed, we're happy to update the exhibit. We will certainly
please
do so.
update it. Thank you.
No objection to that, Mr. Chairman. Yeah, and thank you for running through that. I'm just trying to understand how that relates to that cost. So turning to the two bottom expenses that are below the line, PAC expenses, could you explain what that is?
Those are labor costs that an employee who supports our employee PAC time marks saying, I should not, I'm a government affairs employee, but I'm supporting the PAC. Those costs are then for those employees that mark themselves with that time to say, hey, we do have an employee PAC. And so that's excluding the labor hours that go into, or the time hours that go into supporting that PAC for their against their salary.
Okay,
So that
just
we're
for
not charging
clarity.
customers.
I'm sorry.
Yeah.
For clarity, what do you mean by employee PAC? What is the PAC?
Washington Gas Light has an employee PAC.
What is an employee PAC?
It's a political action committee
Okay.
formed by appropriate employees of the company that have gotten together to ensure that government supports the customers in the community.
And so this number, 42,673, acts as an offset to the salary of that given employee.
Of that government affairs employee, so that it's not charged to customers.
Okay, and that is calculated how?
By the time entry that they do in their system.
So for example, an employee makes 100,000 and of the 2,000 hours they work a year, 20 hours were and on lobbying. So my math is terrible, but they're, that time based on their rate would be what's recorded here.
Objection calls for speculation.
Knows.
I'm not sure if you can ask that question again, Tim. I'm sorry.
I'm not sure if I understand the question. Fair enough. Just to clarify, so this would be a product of the salary times that fraction of the hour or day that was spent on those activities.
I'm going to say that yes, subject to the fact that I'm not a expert on a number of those things, but yes, that's generally how I understand it, Tim.
Okay. And the next line, public affairs, EXP, ST, and Fed. Can you explain what that is?
Again, it's other expenses that we have, labor expenses that we've moved out based on employees' recognition of those labor costs not being appropriate to be, to be relevant for section, account 426.
Okay. And those also are self-reported or calculated in the same way as the PAC expense.
It's related to how they enter time and sort of based on our time entry system.
Once an employee records that time, is there any subsequent managerial review of that entry?
There can be, but I'm not aware during the time frame of if I ever saw any of those, but yes.
Would that be usually something that you would review or see, or someone else on?
No, employees are trained to enter time and they have requirements to enter time and they enter their time.
And so you're not aware of additional oversight of those time entries?
Through the normal process annually of knowing what's going on, but no, not specifically every week or every other week.
Okay. Mr. Chairman, I'd like to approach the witness with what was previously marked as Sierra Club Exhibit SC13, WGL's response to Sierra Club Data Request 2-1. If I may approach the witness. I believe you have a copy.
We have a copy of this as well.
Okay.
This is another data request that Sierra Club had served on the company. And looking at page 2, Mr. Steffes, you had sponsored the response, correct?
Yes.
And this is referring to questions regarding the lawsuit brought by Washington Gas and others to invalidate the Clean Energy DCE Building Code Amendment Act in the U.S. District Court for the District of Columbia. Now, following a motion to compel response, you indicated that to ensure proper cost allocation, that the company uses a system of internal controls that provides reasonable assurance that costs are recorded to appropriate accounts. Is there anything different beyond what you just explained to me about lobbying costs as to how these types of expenses are coded and controlled? That is litigation expenses?
This is an invoice. Those were labor costs. This is an invoice related to this litigation. As I say, if an invoice is coded direct, then there's generally no allocation. And otherwise we apply it across to by the allocation scheme as it references WGF2.
I'm just trying to understand your response here where it's saying that invoices are reviewed and approved by management personnel in accordance with the company's delegation of authority. Can you tell me what the company's delegation of authority is?
The company's delegation authority is that depending on the scale or risk of a transaction, different layers of management have to be aware or approve the transaction.
So can you tell me what the designation is for litigation expenses that falls within that delegation of authority?
I cannot because I do not oversee litigation expenses, what the DOA is for litigation expenses. I'm sure the company has its DOA on litigation expenses.
Okay.
I'm not an attorney.
But you had sponsored this response.
I sponsored this
Indicating-
response as a witness in the case because it's accurate and I'm not a litigation DOA expert.
So this would not fully describe what the company's relevant controls and adequate assurances are that these are recorded accurately.
So that's true. We do that. The controls invoice are reviewed and approved by the appropriate management. I didn't approve this invoice is what I guess I'm saying.
Okay, but what I'm getting at is that you are not in this response or in your testimony otherwise really getting into the details about how these are appropriately recorded.
No, I am saying that they are recorded based on their internal controls and by approvals of the appropriate DOA.
But what are you basing that on? What are you basing your knowledge that they're
Based on my conversation with people that would be relevantly aware of this.
specific to this litigation expense?
Specific to this litigation expense.
With whom did you speak about this recording of this specific litigation expense? If you can recall.
I spoke to Karen Hardwick, who was our past general counsel.
Okay. And was Karen Hardwick responsible for overseeing this delegation of authority and this review chain for this litigation expense?
The general counsel for the litigation expenses would have been responsible for that.
Do you recall when your conversation with Karen Hardwick occurred regarding this specific litigation expense?
No.
Do you recall the content of that conversation in regards to whether to approve or not approve this litigation expense?
No, it was just that there were litigation expenses related to this lawsuit and they were going to be charged.
And do you remember if you inquired whether the review had occurred within her department about the recording of this expense?
I honestly don't remember any more details about the conversation.
Okay. Mr. Chairman, I'm going to approach the witness who was pre-marked as Sierra Club Exhibit SC15, SC16, and SC14. And those are responses to to Sierra Club's data request 22, 23, and 24. They were previously admitted into the record. You should have a copy of these, correct?
You have a copy.
If I may?
Yes.
Mr. Steffes, what you have in front of you are, I believe, your responses to the DRs 22, 23, and 24. They're asking similar questions as to the last exhibit regarding 3 other litigations in Maryland. And on SC 14, in response to 2-2, on page 2 of 2 of that exhibit, you say, please see response to SC data request number 2-1. And on sub A, you say, please see response to SC data request numbers 2-1.a. Is that correct?
On SC 14, page 2 of 2,
Yeah.
I say those things.
Okay. And would you say that your responses now to my line of questioning about the controls in place for litigation costs for these litigations, or so sorry, for the previous litigation hold true for these litigations?
Which litigation?
So going through them, there is first Washington Gas Light versus Montgomery County. I believe this is in regards to the complaint seeking to invalidate Montgomery County's building code. SC 15 is in regards to Washington Gas Light v. McElwain, which is a complaint in an effort to invalidate Maryland State Building Energy Performance Standards. And SC 16 is in regards to Washington Gas Light versus Montgomery County, which is a complaint in an effort to invalidate Montgomery County's Building Energy Performance Standards. So in regards to those three litigations and the controls for accounting and recording of costs expended for those litigations, what you had just told me about the DC litigation would also hold true?
I'm going to object here. This is cumulative. All of these documents are in evidence. The responses clearly speak for themselves. Refer back to the response to 2-1 and 2-1A.
I would respectfully say that this commission before has ruled in previous orders that referring in discovery responses, referring back to previous DRs is not responsive. I'm just trying to get additional information in regards to Mr. Steffis's sponsored responses here to see if they match with what he more fulsomely responded to in regards to the DC litigation. It is not cumulative. I am asking separate questions in regard to these specific litigations, and they've not been asked and answered, and they're not otherwise barred from seeking that information through this. So,
While the DR does clearly state the answer to these questions, I would just ask that the witness answer these questions live on the stand in a yes or no format, or to the extent he needs to.
I can break it down if you'd like by litigation.
Yes.
Okay. So you previously testified that in regards to the DC litigation, you were not specifically aware of the recording of these costs or the controls of these costs.
No, I said that we follow our appropriate internal controls.
But you
I did not approve the invoice is what I said. Because it would
And-
be against the control of the company for a government affairs person to approve a litigation invoice.
Okay, but I believe you said that the general counsel, you had a conversation with the general counsel about the recording of costs for the DC litigation, but you do not have a recollection of your conversation regarding that specific litigation.
That's true.
Did you have a conversation with general counsel's office about the litigation expenses in regards to 2-2 Washington Gas Light versus Montgomery County?
I don't know if you want to go through the three pieces of Maryland litigation. I honestly don't know if we spoke about in that level of detail all four pieces of litigation.
Okay.
I don't remember.
Okay. Return back to what was previously marked at SC 27, page 2 of 3. So that's your response to Sierra Club data request 2-1 to 2-4. Top right corner of the page should say Sierra Club exhibit SC 27.
What number? SC what?
27. And this is a breakdown of the litigation costs for which litigations?
You're talking about Sierra Club 27 exhibit?
Yes. Page 2 of 3.
I'm sorry, counsel, can you repeat that question for me so I can just?
I'm asking if the chart, what litigation expenses the chart here represents.
This subject, there's a lot of, this relates to the DC component. As my response says on page 2 of 3, WGL is not using district ratepayer funds to finance the litigation in data request 2.2, which relates to one of the Maryland cases. And then as my response clearly states, it breaks down the $14,189 included in the test year related to the, my understanding, to the DC litigation that we referenced. The first clause, which was question number 2.1, Washington Gaslight et al., BBC et al., 4-CB.
So these costs here are not associated with legal expenses for the litigation referenced in data request 2-2.
That, yes.
Other than looking at that now, do you have an independent understanding that this chart does not include expenses from any of the 3 litigations in Maryland?
Yes.
So it says here the subtotal here is $76,108, $108,060. DC allocator 18.64, which comes to 14,189. What does the DC allocator mean in this context?
It means when we have costs that cover beyond one jurisdiction, then we go through and we allocate those costs to each jurisdiction based on factor.
So the remaining 81.36% of the $76,108.60 is being charged where?
I don't state anything about where the remainder is going.
So there is this total litigation cost for the DC litigation, correct? For this time.
As I say, we are charging in the historic test year $14,189.
Okay, but I'm trying to understand how you arrived at that number and how it is tracked in the rate making process. So
Invoices for legal services came through those periods. 76,000, we allocated 14,189 to DC in the historic test year rate.
why are you only charging 14,189 to DC?
Asked and
DC
answered.
litigation? This is a separate question, Mr. Chairman. It has not been answered by the witness yet.
Please answer the question as to why that percentage amount is allocated to DC.
Because there's an allocation factor that my accounting, however, the team does it, and that's the allocation, I think, subject to check, 76,108.60 times 18.64%. Rounded would be $14,189.
So in sponsoring the response to this question, you were aware of the total litigation costs for this time period being $76,108.60, correct?
I asked people to pull that and give me that information, yes.
Who did you ask for that information?
Someone in the legal department.
You think there's someone in the legal department who could better answer this question?
No, I think.
Objection, scope, and relevance at this point. The witness has verified where he got this information from. Counsel at this point is going on a fishing expedition.
Yes, please move on,
Yeah.
counsel.
I'd respectfully respond, Mr. Chairman, that this isn't a fishing expedition. This goes, again, exactly to how these costs are properly allocated, how they're recorded, which is squarely within what the commission put in its scope of the issue of this, that again was not modified by the order on the third motion to compel or otherwise. if Mr. Steffes or another witness that's put forward here by the company cannot answer these questions, that is a problem in the sense that WGL has not justified why is seeking this amount of money in its request for rates here.
You have asked about the cost of litigation. You've asked about how the cost is allocated. He has given the basis of where he got that cost information and has told you how it's been allocated. So, and it's also been written in the discovery request response. So please move on.
Yes, Mr. Chairman, I'll just ask one last question in regards to this. And again, as a separate distinct question, are you aware of another witness here today that can answer questions specific to this allocation?
Objection, we're going down the same route that we just did on this.
I'll allow him to ask that question and answer it if he knows.
I'm not aware.
Okay.
Which witness?
One last question on this. Would it be fair to say that if 18.64% is allocated to DC, that the remainder of these litigation costs are being allocated to other jurisdictions?
Objection, scope and relevance. What is at issue in this case is the amount included in the DC revenue requirement and being charged.
I'll allow this question.
I don't know. I never asked that question to the other parties.
Okay. Thank you. Just 1 second, checking to see if I have additional questions. I believe that's all I have. Thank you, Mr. Steffes.
Thank you.
Thank you. DC government?
We have no further questions to ask Mr. Steffes.
Thank you.
Are you free to direct, Your Honor?
Yes.
Mr. Steffes, do you recall questions from counsel on behalf of Sierra Club with respect to whether lobbying costs are included in the revenue requirement in this matter?
Yes.
I want to be clear, where and what account does the company record its lobbying costs?
Work USOA 426.
426.4?
Let me. 426.4.
And have all costs associated with 426.4 been excluded from rates?
To the best of my knowledge, yes.
No further questions.
Thank you, Mr. Steffes. You're excused.
Thank you.
Next is WGL witness, Ms. Kimberly Bale.
Your Honor, understanding that we do want to keep this moving, would it be in the interest of everyone in the room to take a brief break? Just 3-5 minutes, no more than that, for opportunity to use the restroom.
That's fine. We'll take a break.
Okay. Thank you, Your Honor.
Oh, okay.
All right. Witness Bale. Thank you. OPC?
Thank you,
Oh,
Chair.
sorry. First, you want to swear the witness in?
Can you please rise? Raise your right hand. Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth, ma'am? Thank you, and please be seated and pull your microphone a bit close if you would.
Hello, Mrs. Bell, how are you? Oh, Miss. I should have said Miss Bell. Thank you. My name is Bavita Modi, and I represent the DC Office of People's Counsel in this case. How are you today? I'm going to first ask you some questions related to your direct testimony, Exhibit WGH. Do you have that in front of you? So first on page 2, lines 11 to 17 of your direct testimony, you state that the purpose of your direct testimony is to provide, quote, support and detail for the company's request to account for the recently issued IRS or Internal Revenue Service private letter rulings or PLRs. And the numbers are 202462002, 202462003, and 202462004. Do you see that?
Yes. That is,
And for ease of reference, I will refer to the 3 PLRs using only their last 2 digits, i.e. 02, 03, and 04, or as the first, second, or third PLR if needed, to refer to them separately. Is that okay?
that's fine.
You have provided those 3 PLRs in your direct testimony in Exhibit WGH2, correct?
Yes.
Before we go on to the PLRs, have you ever prepared a private letter ruling for submission to the IRS for WGL or any other entity?
No, I've never provided or prepared a PLR.
But you are aware and you have acknowledged in your testimony that PLRs apply solely to the taxpayer at issue in the PLRs, correct?
Yes, yes,
Thanks. The PLRs relate to net operating losses or NOLs for short, is that correct?
yes,
And net operating loss carryforwards are considered assets which arise when a company's total tax deductions exceed its taxable income, correct?
that is correct.
And they are recorded as a deferred tax asset or DTA for potential future use, correct?
That is correct.
Thank
I need to expand on these PLRs are specific to tax normalization around the DTA and OLC.
Thank you for that. And it is your position that the 3 PLRs provide guidance to WGL that under the IRS's tax normalization rules, WGL's net operating loss carry forward cannot be reduced by payments WGL received from its affiliates pursuant to certain tax sharing agreements that WGL has with the affiliates, correct?
The PLRs definitely put us on notice. It's the tax analysis within the PLRs that WGL looked to make their determination that they have a tax normalization violation.
You said that, I did not follow the.
There's a bunch of facts within the PLR.
Mhm.
But WGL looked to the tax analysis, which references the tax code, the Internal Revenue Tax Code, Code Section 168 and 167. That's what we look to. Like you had indicated, the actual PLRs are not precedent to taxpayers outside of the issued PLRs, but all other taxpayers would look to the tax analysis to determine if they too fall into that tax normalization requirement.
Understood. On page 3, lines 4 to 6 of your direct testimony, you state that, quote, "The company facts are the same as reflected for the taxpayer in the PLR." Do you see that?
I do.
Are you stating the company facts are the same for all 3 PLRs attached to your direct testimony or just one of them?
Well, in this question and answer, I was specifically referring to the relevant facts the IRS uses in the PLRs, which we applied that same fact pattern to WGL. As we know, the PLRs are actually addressing electric utility companies, and of course, Washington Gas is a gas company. So
But my question is it one of the PLRs or
all 3 address the NOLC, the reduction based on the tax sharing payments.
Have you reviewed the IRS unredacted version of the 3 PLRs?
No,
And do you agree that unredacted versions of PLRs are issued only to the specific taxpayer requesting the PLR?
yes,
And would you also agree that the confidential versions of the PLRs could include different or additional information than what is summarized in the redacted version of the PLRs that are published?
yes,
The 3 PLRs don't include copies of the taxpayers' tax sharing agreements and related details, do they?
that's correct. I didn't see it.
Have you been able to review the specific tax sharing agreements of any of the taxpayers at issue in any of the 3 PLRs?
No, I have not.
Have you reviewed the tax sharing agreements of any other companies besides WGL?
N- uh, I'm trying to recall because I previously worked at Pepco. So I was trying to recall, we did at Pepco have a tax sharing agreement, but I wouldn't be able to recite exactly what is included in there.
That's fair. Do you know if the tax sharing agreements of each of the PLR taxpayers is the same as that of the WGL tax sharing agreement with ACES?
I would not be able to.
Do you know if the payment mechanism for utilization of tax attributes, including the NOL, by entities at issues in the PLR are the same as WGL's with its affiliates?
If the tax allocation payments, specifically like a ratio or, no. I only know the information that's in the PLRs themselves.
The WGL tax sharing agreement was provided as a confidential exhibit to your rebuttal testimony, Exhibit WG2H, and specifically as Exhibit 2H-3, correct?
I believe that is the case.
You have your rebuttal testimony in front of you?
I do.
Okay, great. And was that tax sharing agreement filed with the Virginia State Corporation Commission on March 11, 2024?
That sounds about right, the timing.
And it was filed as a public document, correct?
That is correct.
Mr. Chair and Commissioners, my colleague, Ms. Diamond, would like to hand out OPC Cross Exhibit 24 to the witness. Would you also need a copy?
No, if it was pre-filed, I have a copy of it. I believe we all have copies of it.
Ms. Bell, Ms. Diamond will be showing you OPC Cross Exhibit 24, which is WGL's public filing with the Virginia State Corporation Commission of a tax sharing agreement that was filed on March 11, 2024, with an agreement effective date of July 7, 2023.
Okay.
You have that now? Has the company revised this tax sharing agreement since it discovered the PLRs on that are at issue in this case?
No, I don't recall that we have.
Is that still the effective
Maybe.
agreement to your knowledge?
I'm sorry?
Is that still the effective tax sharing agreement between WGL and its affiliates to your knowledge?
Believe 2023, that would have been, yes, this is still effective.
Is it your position that WGL does not need to change the tax sharing agreement to correct the normalization violation?
Objection, scope, and relevance here. The issue set for hearing was whether or not the facts set forth in the PLRs are similar to the facts on circumstances presented by Washington Gas. Whether or not the company needs to revise the tax sharing agreement is irrelevant to that determination.
Your Honor, the question and issue that has been set for hearing relates to the factual circumstances associated with that. And one of the issues that the commission said we could probe are the tax sharing agreements and how they differ. And so I wanted to confirm if WGL has changed their tax sharing agreement, as that is a relevant fact in comparing between the PLRs and WGL situation.
I'll allow this question.
No, we have not changed the tax sharing agreement.
So would you agree that this suggests that WGL intends the commission has to change the rate-making treatment to address the normalization violation, but the tax sharing agreement does not need to change?
Objection, again, scope and relevance. This doesn't go to a comparison of facts and circumstances. This is going to a legal conclusion as to who has to take what action with respect to the tax sharing agreement in effect.
Sustained as to the last part of the objection.
In your direct testimony on page 5, lines 15 through 18, you state the 3 PLRs find that any payment reducing the DTA NOLC for rate-making purposes constitutes a normalization violation. Do you see that?
Page 5, line
15
15.
to 18.
Yes.
And on page 7, lines 16 to 18, you state that another PLR with number 2017090008 stated that if any portion of the DTA NOLC that is a result of a NOL generated by accelerated tax depreciation is excluded from rate base, it violates the normalization requirements of the tax code provisions you cite there. Do you see that?
Yes, that's pursuant to the code, yes.
Do any of the PLR rulings specifically state that the related PSE is required to pass on rate increases to customers for the impact of the ruling?
Does the IRS code indicate that? No, it doesn't stipulate that the code doesn't. It just provides how to account for the DTA,
How about,
NOLC for rate making purposes.
how about the PLRs? Do they specifically state that the commission at issue is required to pass on the rate increases to customers for the impact of the PLRs?
I'm going to object again here. This is probing for a legal conclusion as to what the commission is required to do in this circumstance versus what other commissions may or may not have been required to do.
I'm asking her of the reading of the PLR and whether it says that. I'm not asking her to draw a legal conclusion.
Please answer the question.
The question is, does the PSC require the pass-through? Can you
Sorry, I'll
repeat the question?
Do any of the three PLRs that you've read and cited in your testimony specifically state that the related PSC, the state commission at issue in those cases, is required to pass on rate increases to customers for the impact of that ruling?
The PLRs do indicate that there is a tax normalization violation. And therefore, if that is the ending result, that's what the PLRs indicate.
But it does not specifically reference ratepayers and what the state commissions at issue should do with respect to the
It does indicate that based on the Internal Revenue Code, that there is a normalization violation. Thereby, each of the three PLRs that were cited, they had reduced the DTA NOL, and therefore, if you increase it, you inevitably will have that impact.
When you say inevitably have that impact, that's if the commission allows it, right?
Well, that's why we're here, to seek the approval of the commission to follow the IRS guidance.
Are you aware of any a DC Public Service Commission rule that makes it unnecessary for WGL as a taxpayer to obtain its own PLR?
Am I familiar with any rule which require WGL to seek its own PLR? Is that your?
No, that makes it unnecessary for WGL to obtain its own PLR.
Well, I believe based on the three private letter rulings, the information is clearly identified, and the relevant facts are synonymous with WGL's facts. Therefore, we don't feel that we don't need a private letter ruling. We don't need to seek one because the facts are clear in the PLR. It addresses the tax analysis under Code Section 168 and 167. And so we do believe that if we seek one, we would get the same result that's already out in these existing PLRs.
So if the three PLRs relied upon by WGL in this case were overturned or subsequently modified by the IRS, would that impact WGL's position in this case?
Objection is speculation and future events.
Sustained.
Does it state anywhere in the IRS PLRs that the state commissions at issue cannot mitigate the impacts on ratepayers through amortization of the amounts to be added back to rate base?
In the PLRs, does it indicate an amortization of the restoration of the DTA NOLC? Is that what you're asking?
Does it state anywhere in the IRS PLRs that are the redacted versions you've reviewed that the state commissions at issue in those cases cannot mitigate the impacts on ratepayers through amortization of the amounts to be added back?
I don't understand your question. Can you rephrase the question?
Do the PLRs at all talk about whether the state commissions can require the company at issue to create a regulatory asset or liability, or how many years by which the company can recover the costs of the reversed NOLC?
Yeah, so first, I think we first have to understand that the three PLRs confirmed that there was a tax normalization violation. Then the next step is to determine how to remediate that tax normalization violation. And, that's why we're here, to get the approval from the commission to include the adjustment in the rate case. There are stipulations in terms of setting up a regulatory liability whereby the company could possibly, if they decide that we need to go and get a PLR, we can set up a regulatory liability subject to the private letter ruling being issued. And then we could return that if the PLR is not in WGL's favor, not consistent with the existing PLRs.
So you
But we cannot
agree-
not do anything.
So you agree a step would be to get your own PLR?
I believe the existing PLRs covers WGL's fact pattern. The relevant information in these PLRs are applicable to WGL. It's almost as if reading WGL's fact pattern against the existing fact pattern, and we don't believe that there would be, we don't believe we need to go and seek one. We believe that the fact pattern that exists out here now for the commission to consider is relevant and consistent with WGL's fact pattern, and therefore we don't think that we need to go get one. If we have to get one, we believe that the results will be consistent with the existing three PLRs that have been issued.
You are speculating the IRS would rule the same for WGL under WGL's fact patterns as they have ruled in the underlying PLRs?
Based on review of the Internal Revenue Code 168, which says that we are a regulated utility company that has public utility property. And we, record deferred tax liability and deferred tax asset, NOL, associated with accelerated depreciation. The facts are mirrored, to WGL's fact pattern.
You agree that the three PLRs state at the last page of each of the PLRs that, quote, while this office has not verified any of the materials submitted in support of the request for rulings, it is subject to verification on examination, end quote.
Yes. Material is, these are electric companies, Washington Gas is a gas company. That's material. It's just the relevancy is Code Section 168 address utility companies, regulated utility companies, which include electric, gas, water, and telecommunications. So we would fit under that 168 code.
So it's your position that in that statement that the IRS said, while this office has not verified any of the materials submitted in support of the request for ruling, it is subject to verification on examination. That statement is only as to a difference between electric and gas companies?
No, I'm sure that there are other fact patterns in these PLRs, but the IRS specifically highlighted relevant information on page 13 of the PLR, where it specifically says relevant. So that's what we reviewed in the tax analysis, the relevant information, compared it to Washington's Gas relevant information, and came to the same conclusion that we had a tax normalization violation.
I'm going to show you what was previously marked as OPC 126. It was filed yesterday, and I've conferred with WGL counsel, And he has agreed that I can present this to you, and I will introduce it here as Cross Exhibit 19. This is a WGL response to Commission Data Request 3-6. Your Honors, I will have Jelaine also provide you a copy if you don't have it, but it was filed yesterday and listed in our July 29 list and served yesterday as OPC-126.
Thank you.
Thank you.
In response to Part B of that response, you have co-sponsored this response with Mr. Gibson, correct?
That is correct.
And in response to Part B of WGL's response, you and Mr. Witness Gibson believe a regulatory liability should be established if the IRS reverses its position, correct?
That is correct.
And it is your testimony that WGL should not seek its own PLR, but if it does, then the IRS reverses its position, you believe a regulatory liability should be established, which would allow you to recover the costs from ratepayers.
Yes.
Yes, right? Yeah.
Yes.
Okay, thanks. In response to Commission Data Request number 3-3, which is pre-marked as OPC Cross Exhibit 25,
Yes.
do you have that? Or we can provide you a copy?
Mission Data Request 3-3?
Yes.
Yes.
It's OPC Cross Exhibit 25. You state in Part C of that response that you believe the IRS would arrive at the same conclusion for the facts in WGL's case, right?
Yes.
Um,
Based on, yes, the relevant facts. Mhm.
Did the 3 PLRs or any other PLR you have reviewed find that it is improper for a state regulatory commission to await an IRS PLR ruling before the normalization violation is confirmed with the IRS?
Did any of the, you recite that question again? Because I just want to be clear that I answered
Sure.
that
Sure.
completely.
Basically, I am asking if any of the 3 PLRs
Mhm.
have said if the state commission will wait before the PLR is confirmed and a normalization violation is confirmed, that would be a violation of the normalization requirements. Did any of the PLRs say that?
No, it doesn't indicate that if the commission, well, I think it's important to separate if we seek a PLR and if we do not. So based on the fact that we have a tax normalization violation, the remediation is to get a decision at the earliest opportunity, right? So this is the earliest opportunity for Washington Gas in the District of Columbia. So the commission, in this case, we will need to decide, if we include the adjustment in the rates, if they require us to get a PLR, which we don't believe we need, then we could establish a regulatory liability. But that would mean that the commission has made a decision in terms of, considering the regulatory liability.
But it would not be a violation for this commission to wait for a private letter ruling if it decided to require WGL to get one.
Let's be clear, waiting, when you say wait, the commission has to do something today. We've recommended a regulatory liability. First, of course, the ideal thing would just to include it in rates. And so you don't have to wait or defer until to get a PLR. The alternative is to seek a PLR, but that means the commission has made a decision. But a decision has to be made to remediate the tax normalization violation. Otherwise, there are more significant ramifications associated with not remediating this tax normalization violation.
When you referenced the entities in the 3 PLRs, you said they are electric companies. Do you know which companies are at issue in that are the taxpayers underlying those PLRs?
I believe based on some of the guidance that has been out there, I believe maybe the parent is AEP, but I'm not sure of the subsidiary, so I don't really know the full spectrum of who. So I'd rather not speculate. But that, knowing if it's AEP or Dallas Electric doesn't define what makes the tax normalization a violation. It's the fact that we have reduced our DTA NOLC by the tax sharing payments. Thereby, we've, adjusted the rate base inappropriately. And so we have to correct that.
I'm showing you what is OPC Cross Exhibit 20, which is a motion submitted to FERC by the American Electric Power West Companies, which is AEP, as you mentioned in your response. This was submitted to FERC in docket number ER 18194.
I'm sorry, it's in my book?
It's a Cross Exhibit 20. Yes, it should be.
I'm going to object to reference to this exhibit, and I have several grounds for this. Number one, this is a legal submission by other utilities before another regulator, and to the extent that counsel is specifically going to refer to portions of the motion itself, those are legal arguments and statements. They are not related to the factual content of the PLRs themselves.
I have not even asked my question yet, but I will say that the limited reason I am raising this exhibit is first, the witness already knows it's AEP, and she didn't know who the others are, and they're subsidiaries of AEP, which is stated there. And just to confirm that the same PLRs that are at issue here were brought by the company itself there and its subsidiaries.
I'm having a hard time understanding how this witness will have knowledge of this particular document. While she does acknowledge that she thinks AEP is one of the PLRs, is one of the companies from the PLRs, her knowledge of this actual pleading and the facts within this pleading have not been established. And further, it does not relate to, at least right now in its face, how this ties into the material issue of fact as identified by the commission.
The reason I'm raising this is not for her knowledge of the specific statements in that motion. It's basically each of these subsidiaries are affiliates of each other, and they each got their own private letter ruling, which is different than her position that some facts of another entity totally can be relied upon to obtain a private letter ruling. So it goes directly to the factual differences between the PLRs, the entities in the PLRs, their actions versus WGL's actions are all material issues of fact in dispute. And as to the positions WGL is taken in this case versus what OPC's position in this case is, that they should obtain their own PLR.
If I may, Chairman.
Yes.
The one thing I would add further is the argument presented by counsel here. This goes to the ability of another taxpayer to rely upon those PLRs, specifically whether they are one entity, multiple entities. That's the purpose for which these questions are being asked. And if that is the case, that issue was clearly not set for hearing. It was a second part of the question that was reviewed and submitted by OPC. And the commission has ruled that that issue is a legal and policy decision for this commission. It's not a factual dispute.
I'm not raising the legal issue of whether it's non-precedential. I've not even asked her for a question on precedent or not. It is a factual difference in position where 3 subsidiaries each got their own private letter ruling, and how that relates to the WGL position. The commission in its order setting this case for hearing, setting this issue for hearing, specifically stated that the commission, the dispute involves determining whether factual elements such as corporate structure, tax sharing arrangements, regulatory treatment, and specific tax positions are materially identical between the rulings in WGL's case. This goes into the differences in regulatory treatment. It goes into the differences on their corporate structure and how that relates to WGL. So I submit it is within the scope of issues.
So
It's limited.
Yeah, it appears to me that you're trying to establish the fact that Washington Gas has the ability to get their own private letter ruling, if I'm understanding you correctly. And I think we've heard you articulate that position several times. So the commission is certainly aware that that is an option that Washington Gas has before anything else occurs, if that's the point you're trying to make.
Your Honor, I was trying to make a separate point that even subsidiaries of each other do not rely on their own facts or the other IRS PLR issued to the other. They get their own.
Okay. And so then that gets me back to what I said before. By you trying to introduce this document to the witness that she is unaware of, I'm not sure you can lay a proper foundation for it.
Sure, that's fine. We can move on to
Okay,
that
thank you.
exhibit. Are you aware if any entity has disputed the PLRs at issue?
Am I aware of any entities that have disputed the published private letter rulings? I believe what was submitted, was it last night, I believe? Not that I can coherently discuss. I'm not aware, other than what was presented last night, which I cursively reviewed, the exhibits that were provided. But I think those, exhibits actually more so support our position, that we have a tax normalization violation and we need to remediate it. The options, as we've laid out in terms of, including it in rates. I mean, that would be, great because there will be less of an administrative burden, but the alternative is the regulatory liability. And so, I mean, again, we don't believe we need to seek a private letter ruling. The tax analysis contained within the private letter rulings are factually based on WGL's relevant facts as well. So,
Is it your position that even if the IRS changes its position on the PLRs, you would still want this commission to act based on the PLRs?
Objection calls for speculation.
I am not asking for speculation. I'm asking her position.
Well, if I could interject for a second, can I get a clarification on exactly what you're asking this commission to do? I'm not clear from Washington Gas. What are you asking? What are you asking us to do in the absence of a PLR?
Your Honor, would you like me to answer this question
Yes,
or with a
please.
witness? So the two items that Washington Gas has proposed with respect to the NOLC DTA issue are as follows. Number one, the commission can adopt the adjustment that the company proposed as a part of its direct case
Based on,
based upon the factual circumstances being similar and Washington Gas having demonstrated those facts and circumstances are similar, and that it is necessary for it to do this to comply with the tax code.
so you're asking us to determine whether or not there's a tax normalization violation.
We believe that there is. We're asking
Are
for.
you asking us to determine that there's a tax normalization violation?
No, Your Honor. We are asking the commission to state that this is the appropriate regulatory accounting treatment or a tax normalization violation.
And how do I get to that treatment without determining that there was a tax normalization violation?
Two ways, Your Honor. Number one, I can lay the foundation with this witness on redirect as to why we do not need to obtain a PLR or the commission to take this action for purposes of regulatory accounting treatment. And then number two, I would just to loop back to your first question. The other option that has been presented here is that if the commission determines that Washington Gas must seek a PLR and orders the company to go do so, it should establish a regulatory liability that will remain in effect while that PLR is pending. Those are the two ways that the accounting treatment could be handled such that an inadvertent normalization violation would not become an intentional normalization violation.
Don't you have to file for a PLR in order to have safe harbor under the tax code? Before
Happy
you
to-
include this case?
I'm happy to explore that with the witness. The requirement for safe harbor is that the utility must reflect this in its rates at the earliest opportunity. My understanding is that is generally its next available base rate proceeding, or in the event that it has a specific tax rider or other surcharge mechanism that would allow it to reflect the impacts of the NOLC DTA. It could flow through that in an adjustment proceeding for that.
This
but
is your next available, this
Yes.
is your opportunity, right?
I
So,
100%.
but I'm just trying to get straight. What is it that you want me to do?
And to, I guess, summate it
Because you
again.
keep, I see this, I don't want to kill a whole bunch of time with my particular questions, but I'm not understanding what the point is. Okay, the witness is pretty much giving her opinion. I know you agree with what she's saying. She's giving her opinion over and over on, she thinks the circumstances are similar. I don't know that anybody's arguing that they're identical. Okay, so if they're similar and that's what she thinks, she's going to keep saying that over and over. The issue is going to be, what do you do with the similarity? Even if you think that they're similar, what am I supposed to do with that if you don't go and get your own PLR?
And again, I think I can lay for that first part, I can lay that foundation upon redirect. It is also reflected in the witness's testimony. It's a concept called voluntary compliance.
Okay, but let me just cut to the chase. You could get your own PLR, right?
Certainly, I do not disagree with that.
And then if she suggests that it would be the witness, I didn't mean to, if the witness is intending to, or has suggested that this could be in a regulatory asset subject to the PLR, doesn't that solve it?
That could certainly, Your Honor. And to be very clear here, part of the reason why this is in dispute is because despite the fact that the company had advanced a proposal to reflect this adjustment as a part of the base rate proceeding, OPC's witness disputed whether even a tax normalization violation had occurred here.
Well, they
Correct?
can't, but they can do that, right? Because you don't have a PLR. I mean, that's the problem here. If you don't have a PLR, and the PLRs that are out there, there are 3. So if you could rely on one, there should only be one then. But there are going to be multiple PLRs that people can think fall within certain fact patterns. But thinking whether it falls within a certain fact pattern doesn't turn it into a PLR on its own. So what I'd like to do is, to the extent that that's possible, I'd like to stay out of the tax code myself or do things that are interpreted as making tax normalization violations decisions for the tax, for the IRS. I think there's a simpler way to do it, and the witness suggested it.
Well, I think, just if I may interject, I think the IRS has made the determination already, right? Because the IRS in the code section has indicated that if you reduce the DTA NOL for anything other than accelerated depreciation, which is what we've done.
You're
we've
talking about the
reduced-
PLRs, right?
No, I'm talking about the tax law.
Are you talking
Tax
about
law.
as interpreted through the PLR, or
Yes,
you're talking about
yes.
something else?
The tax law
Okay,
that
so
they
it's-
address in the PLR. They specifically give us the
I'm just trying to be
IRS
clear on something.
guidance.
The PLR says that, I thought, that it's only applicable to the taxpayer who asked for it based on the specific circumstances for that taxpayer. That's fine if everybody thinks that something is similar to another, but it still gets me to what will I do with that? Okay, everybody thinks it's similar. We can all, maybe we agree, maybe we don't. How close is similar? I'm still trying to get down. What do you want me to do with that?
Your Honor, if I could, I would just note, we did not flag this as a factual issue for the commission to determine. And frankly, I would say that this is ultimately a legal and policy determination for the commission. That said, this witness has been presented to address a factual issue identified by the commission. She's attempting to do that.
I understand that. And I didn't think it was a factual issue myself. I'm just trying to get through this. If there's something that we can all agree on so that there's nothing else to question this witness for, maybe there is something else you want to question her on, but I think she's going to say the same thing repeatedly, that in her opinion, it's similar enough, and that this is enough of a protection based on the PLRs we have that we can do whatever it is she's suggesting we do. OPC is going to say that you need your own PLR. I've said something in a dissent, so it's not like everybody doesn't know what I think. So I'm not trying to have that argument, specifically on the legal question. I'm not really trying to do that. I'm just trying to get through this so we can see whether or not we actually have something that's an issue of fact that you need to pursue further, or whether this is just a legal argument and you're going to take care of it some other kind of way.
And Your Honor, if that point of clarification is what is required, the rejoinder testimony of Aaron Gibson specifically lays out, I would say, what the company has proposed must be done here. So that has the two regulatory accounting treatment options spelled out in detail that Ms. Bell has been discussing. And I would say the company, if either of those two actions are taken, the company under the tax code and its interpretation thereof will have avoided an intentional normalization violation, which is the point of us proposing these adjustments.
Okay, let me
Yes.
cut off OPC. So go
Uh,
ahead and proceed with what you were doing. I don't want to hold this up and make it any longer than it would otherwise have been. I was just trying to get a little clarity, if I could, to shortcut some things.
Thank you, Your Honor. A lot of the colloquy between Mr. Lynn and yourself really relates to legal issues, and we would reserve the right to respond to those in our final briefs. We're trying here to stay on the specific narrow piece of this NOLC issue that is set for hearing. We reserve the right to raise the full NOLC issue, including with respect to the regulatory treatment proposed by the company in our final briefs. And so I will not waste time on that. However, Your Honor, in responding to this, Ms. Bell has now has made a statement in which she's saying the IRS code, not just the PLRs, have told her that what WGL has done is a normalization violation. And so I would like to ask her a couple of questions based on this new position.
Wouldn't that be legal?
No, it's a question on her position.
Isn't her position legal?
Her position is legal, but it is stated by a witness. I
But
respectfully
it's not
request.
factual, right? I'm just trying to,
Well-
we can take a lot of time going through this, and I really don't want to impair your ability to ask questions. But listening to it, I have to make decisions on these issues. So it's not just about what the parties want to say. It's also what I think is helpful in making the decision. And I think we're kind of getting off the track. I understand your point. You're walking a line. You walk it very well. I appreciate that. I'm not criticizing anything you're doing. I'm just trying to see if we can move this a little more quickly.
Yeah, I understand, Your Honor, and I appreciate it, but there is one factual issue raised. Ms. Bell has stated that this is the first time they have become aware of their violation is through the PLRs. And now she's stating that the tax code, which has been around since 1986, is the reason they are confirming they have a normalization violation. And so I wanted to ask her simply the question, if she is now stating it's the IRS code and not that the PLRs that they are relying upon to say that this is their first opportunity of discovering their violation is a new position by the company.
So that's again outside of the scope, right? We're talking about the factual circumstances of the PRL and whether or not the factual circumstances are the same. The fact that now the witness has stated that the IRS code has informed her decision, and I believe the way she cited that was in relation to the classification of a utility, has no bearing on the specific material issue of fact and dispute, which is the factual parameters of the letter.
Thank you, Chair. My question is is this ruling an indication that we cannot brief the issue, or is it just that it's just not set for hearing because the commission is interested in efficient hearings, but that we are allowed to fully brief this issue?
If you would like to brief the issue, please do. Yeah.
Yes, we will move on and brief the issue. I only have a few more questions, and I will see if I can streamline them, if you could give me a moment. I do have a few more questions. And Your Honors, this will relate to a confidential portion of WGL's responses.
Okay. Hold one second. How long do you think the confidential portion is that going to be the remainder of your cross-examination or?
Yes, of Ms. Bell, and it's just 2 questions. Hopefully it will go fast.
Okay. Since the parties are going to discuss confidential matters, we request that all in attendance who have not signed the confidentiality agreement, please leave the room so the confidential matters can be discussed. We expect this will take no longer than 5 minutes. Okay.
I just have one last question that's public.
Please proceed.
Proceed, okay. On page 17 of Exhibit H2, which is a PLR.
In the direct testimony,
It's, yes, in your direct testimony, a PLR on page 17.
yes. I'm there.
It says, pursuant to the TAA, the profitable members made cash payments to parent for their separate return tax liability, and parent remitted cash payments to taxpayer for the tax benefit derived by the affiliated group from the use of taxpayers' losses. On its financial GAAP books, taxpayer reduced its DTA for the NOLC to reflect the receipt of cash for the use of its loss by other members of the affiliated group, thereby recording an adjusted DTA balance of 0. My question to you is, did WGL also record the DTA balance of 0?
Yes, that's the normalization violation, that we reduce the DTA to 0. And the IRS actually is the governing body that determines the normalization violation, and that's what they have indicated.
So it's your position, it's the IRS that determines the normalization violation,
Yes.
not the state commission, not the.
Well, the state commission would be the governing body to provide approval to include the rates, but the IRS, according to code, the code section 167 specifically says how the DTA NOL should be the full amount of the DTA associated with accelerated depreciation. I mean, that's in the code.
Was
and so
WGL aware of that code prior to 2018?
prior to 18, of course, the code section was there. But I believe at the time, we were following the existing guidance for rate-making purposes. As I had indicated, it's only recently where we've changed that, assuming that, that was the appropriate thing to do. But now the guidance is very clear. I mean, these private letter rulings, it does indicate specifically tax sharing payments, which, I mean, we have 3 of them, so obviously there was some ambiguity, but now we have the guidance to actually look to that's in, and it specifically says in the code section 167. How you should.
So just so I understand, there was a point when you were compliant with the code, then in the years that are at issue in this case, where you've sought about 5-6 years worth of NOLC reversals, it is your view that you were outside of compliance with that code?
That we have a tax normalization violation.
Okay, thank you very much. I have no further questions of Ms. Bell, and I do want to move in. I believe we've been requested to move in all our exhibits, but I understand counsel and we'll look and we will confer during the break as to the full scope of the exhibits we filed yesterday. But as far as what was introduced as cross exhibits, I believe your honors have already ruled on what 24, and that was where you stated that the witness does not know the facts of that WGL's OPC Cross Exhibit 24. We would like to move that into evidence. That is the hard copy version of the tax sharing agreement that was filed publicly with the Virginia State Corporation Commission.
No objection to that.
Thank you. So moved.
I understand that Exhibit 19, which is WGL's response to the Commission's data request 3-6, there's no objection to having that moved into the record.
No objection.
And that'll be exhibit number 19.
Cross Exhibit 19.
Okay.
But I understand that the Commission stated that, I'm sorry, there is Cross Exhibit 25, which was WGL's response to Commission data request 3-3.
No objection.
Thank you.
And for the full scope of OPC 1 through 164 that was identified on July 29 and served yesterday, WGL counsel and I will discuss on a break if they have any objections to that, but we would want to move that in at some point today.
I will let that discussion occur before I rule on it. Any redirect, counsel?
No redirect.
Okay. At this time, the commission also moves PSC exhibits, WGL witness Bale, PSC exhibit 31, 33, 35, 39 through 40 into the evidentiary record at this time. Did you have a question? Sorry.
Mr. Chairman, thank you, if I may, of the witness. Let's assume you're correct and that you had a normalization violation. And that it's my understanding that you have not sought a private letter ruling yourselves. If the commission does not increase your revenue requirement, I guess by this $2.8 million, what happens next? I mean, do you plan to go seek a private letter ruling?
No, we do not believe we need to seek one. I think between the IRS guidance, which stipulates that we have a tax normalization, it's now a method of how do we remediate. If we do not get a decision in this case, that means on the next tax return, the company will not be able to take accelerated depreciation. And then we would also have to reverse our deferred tax liability that's on the books. So it's far more detrimental for us not to do anything in the rate case. The commission can, make a decision to establish a regulatory liability. So we would collect it and it would be subject to, receipt of that PLR. So we would go, and seek a PLR. And the alternative is a regulatory asset. But we cannot not do anything. Because I think the consequences are pretty severe.
Okay, thank you.
Okay. Thank you, Ms. Bell.
Thank you for your time.
Thank you. So it's 1 o'clock. We've made it through 2 witnesses. So we're going to keep powering through and we're going to call witness Gibson. Thank you.
It's remote.
Oh, okay. Thank you.
If I'm being sworn, I can't hear
There he is.
it.
Good afternoon, sir. And no, you're not being sworn in as yet. We were waiting for you to appear in the corner on one of our monitors or all of our monitors. But with that said, we can go ahead and get started. Can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth?
I do.
Thank you.
Bear with us one moment. OPC, please begin.
Thank you, Mr. Chair. Hello, Mr. Gibson. I'm Bavita Modi. I represent the Office of People's Counsel. How are you today?
I'm doing well, thank you.
Thank you. Mr. Gibson, you adopted witness Turanimi's testimony in this case, correct?
With the exception of his qualifications, I did.
To address Commissioner Beverly's request for revenue impact information, is it correct that in witness Turanimi's direct testimony at page 98, if you add up the 3 amounts on lines 8 to 13, and I'll wait till you get it.
Testimony is, voluminous. Okay, page
98.
98, I'm there.
You see the three numbers in lines 8 through 13, some of which are bracketed and some of which are not bracketed.
I see on line 6 through 13, yes.
Would you agree that when you compute that, it approximates about a $26.4 million dollar increase in rate base to account for the NOLC adjustment?
Yes, I think that is fair. If I look at adjustment 32, the total increase just related to the NOLC change is 27,248,768.
And then when you subtract for the EDIT, would you agree it would be closer to 26?
The change that you're referring to is a change to income tax expense and not the rate base.
Right. So is it your position that WGL is seeking to increase rate base by approximately 27 million?
For the effect of the PLR, correct. And to the specific question about the revenue requirement impact, we have a schedule that was filed as a part of direct that calculates the revenue requirement of each of the adjustments. And that is exhibit D2. And you can see on the final line of that exhibit, line 74, adjustment 32, that change in revenue requirement is $2,789,040. Now that is predicated, of course, on the assumption that the commission fully adopts the cost of capital we've proposed in this case, because these are all calculated at the requested rate of return.
Thank you. On page 8, lines 7 to 22 of your rejoinder testimony.
1 second.
Counsel, before you ask your question, I just want to remind you, and this is a general reminder for everybody, let's try and stay within the scope of the material issues of fact and dispute in the guidelines that the commission put out. Thank you.
Rejoinder, page 8. I am there.
On lines 7 through 22, you address two possible outcomes of a PLR. You state regarding a second possible PLR outcome, if the PLR establishes the same treatments as the other PLRs company witness Bale describes, then the regulatory liability would be eliminated. If the PLR establishes that tax sharing of payments may be included as a reduction to rate base, then the regulatory liability would be refunded to customers through a rate reduction over a time period that reasonably represented the interval at which base rates normally change by commission order. Do you see that?
I see that.
Do you agree, based on this, that the factual determinations made in the PLRs could be different than what WGL could receive from the IRS?
Objection calls for speculation.
Your Honor, it's not speculation, it's what the company witness has said if the PLRs treat the same. So it's a follow-up to the company witness's own statements as to what alternatives can happen. I'm not asking about what the IRS could do, it's what his position is.
Right. And I believe what the witness is saying here is that he's giving two alternatives, and it can either be placed into rate base or there can be a reg asset until PLR comes out. And if the PLR comes out with a different, if Washington Gas seeks their own PLR and it comes to a different conclusion, then rates can be refunded. I think that's what that's saying.
So you agree that if the second approach is used and the commission awaits that PLR, that would not be a normalization violation?
So this whole section, the purpose of this section is to offer the commission an alternative. If it wants the company to seek a PLR, right, that's the whole purpose of this section. So if the commission orders us to seek a PLR, this covers the regulatory accounting treatment that we would propose the commission adopt, right? So they would include adjustment 32 in rate base in this case. So rates would rise by the effect of adjustment 32, right? We would, at the same time, based on the commission order, if they adopt this accounting procedure, establish a regulatory liability, right? And that would track the cost that we're recovering in rates related to this increase, right? If we seek and get a PLR and the IRS determines in that PLR a different treatment, then we would refund the difference based on what was recorded in the regulatory liability.
You have read the PLRs, correct?
I'm generally familiar with the PLRs. I haven't read them fully in detail.
Well, if you cannot answer this question, that's fine. But would you agree that the PLRs in this case do not prohibit a state regulatory commission to create a regulatory liability asset but not reflected in rates?
Counsel, I'm going to remind you the scope of the material issue in fact is in dispute here.
That's fine, Your Honor. I will reserve this for the brief.
Thank you.
I have no further questions of witness Gibson. Thank you.
Thank you. Sierra Club.
Yes, thank you, Mr. Chairman, and good afternoon, Mr. Gibson.
Good afternoon.
Just have a few questions. I want to direct you to the direct testimony of witness Terniemi that you say you've adopted at page 75 to 76.
Okay, give me a few
Sorry,
minutes to
Counselor,
get
can you
there
speak?
because I've got to flip back to direct.
Just to repeat, I want to direct you to page 75 and 76 of the direct testimony of Mr. Terniemi.
Yep. Uh, 75 and 76.
Yes.
Okay, I'm there.
All right, on lines 17 on page 75 to line 2 on 76. There, it indicates that The costs were eliminated from the test year expenses totaling $97,796 for trade association dues, business and civic memberships, and support payments of $48,991. American Gas Association dues of $59,768. And this is where my question is. It says here, in addition, I eliminated a net credit amount of $10,962 associated with the company's community affairs program in the District of Columbia. And the footnote adds that the credit reflects reclassification of an amount incorrectly charged to account 930-200 in January 2023. That was reclassified out of account 923-000 in August 2023. Are you aware of what those charges are associated with? And can you confirm, sorry, I'll just start there. Are you aware with which activities those charges are associated?
As stated in testimony, community affairs programs.
Are you aware of the specific activities that occurred in the community affairs program justifying those costs?
No, I don't manage those, no. But I mean, this is eliminated from the test year, so they do not appear in rates in this case.
Well, that's
These
my
are
fault.
elimination adjustments as directed by the commission per precedence in prior proceedings.
Sure, but that's my follow-up question is, it seems to indicate here that there was a credited amount. Was this included in rates in any prior rate case?
Objection,
knowledge?
scope, and relevance here. Now we're asking about amounts in prior rate cases, not even an amount in this rate case?
Your Honor, as part of the issue of these costs being properly accounted for, where and when they were put in the accounts, where were they accounted for is within the scope of that issue.
If this witness knows.
Right, it says in the footnote already that it was incorrectly charged to this account in January of 2023, right? Outside of the test year. And the correction occurred in August 2023 within the test year. So we are removing what is in the test year. What happened outside of the test year doesn't matter.
Okay, I'm just asking you to confirm that this is being, this is ultimately eliminated from rates from WGL.
It is, yes.
Okay, thank you. And that you don't have any specific underlying knowledge of the activities that form, that represent these, that to which these costs are representative, right? Like you don't know what happened in terms of the community affairs activities?
No.
Okay, thank you. Just to confirm, WGL did not include the $48,991 in trade association dues here, correct? That should be on page 75.
Correct.
Nor the AGA dues of $59,768, correct?
That's correct.
And the same for general advertising.
General advertising, correct. Eliminated.
Right. I just want to ask you a couple more questions. I'll be bringing this up with witness Morrow later on about abandonment and costs associated with WGL's activities in responding to customer requests to remove service. But can you point us?
Objection, the foundation laid by this question by counsel is clearly suggesting it's outside the scope of issues set for this hearing.
I'll let him ask the question and then make the ruling.
Finishing my question, in regards to those types of costs, where are those recorded in the testimony or in the attachments in the rate making materials?
Before you answer that question, when you say those costs, what costs are you referring to?
Well, in response to discovery, in response to Sierra Club discovery, to which Washington Gas did not object and answered to, witness Morrow had indicated that there are certain costs associated with removing gas service when a customer opts to terminate.
Mm-hmm.
There are certain costs associated with removing meters. There are certain costs associated with removing the gas lines physically from the property. And to the extent that those are recorded somewhere here, that we would like to know where they are. I think that is a factual issue. And again, WGL did not object to those questions, the witness answering those questions. I'm just trying to understand where they're recorded here from witness Gibson, because when I get to witness Morrow, I don't want to be in a situation where he says, I don't know where they're recorded. That's a question for Mr. Gibson.
Those are outside the scope of this hearing.
With that, I have no further questions, Your Honor.
Thank you. Sorry, any redirect?
No redirect, Your Honor.
Okay. The commission moves PSC exhibits for WGL witness Gibson 23 and 24, 32, 34, 36, 37, 38, 43, and 45.
Objections.
Okay. Okay. Let's keep moving. Next witness is Mr. Ronald White, who is also remote. Mr. Gibson, are you available?
A minute.
Oh,
I am.
sorry, not Mr. Gibson. I meant to say Mr. White. I apologize. Thank you, Mr. Gibson.
I'm available if you can hear me. Can you hear me?
We can hear you. Do you intend to appear on camera?
I was intending to.
Okay.
I think there's something there now.
There we go. We see you. Thank you.
Good afternoon, Mr. White. Can you raise your right hand? Yes, sir. Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth, sir?
I do.
Thank you.
Okay. We'll begin with the OPC. Thank you.
Dr. White, first, can you just confirm that you can hear me?
I can hear you fine. Thank you.
Okay, so I'm Amanda Drennan. I just have a few lines of questions for you this afternoon. So I'm hoping you can clear some things up for me. I'm also hoping to make this as efficient as possible. So before I start, can you confirm that you have these items in front of you or easily accessible? So your direct and rebuttal testimonies and your exhibits WGG-1 and WGG-2. You have those?
I do. I don't know that I have G-1 up, but I'm familiar with it.
I hope so. And I would also ask that you have a copy of OPC witness Andrews's direct testimony, which is OPC-E.
I do.
And lastly, you should have the cross-examination exhibits. So those are pre-identified as OPC cross-examination exhibits 1 through 16.
I have those, assuming they'll all open, but yes, I have.
Sounds good. Thank you, Dr. White. So I'm going to start with your rebuttal testimony. If you could get that up and turn to page 4 and just let me know when you're there.
I believe I have that.
Okay, so starting at line 1, you were asked about a quotation from witness Andrews's testimony. Do you see that?
There's a major increase. I do.
I assume by putting this phrase in quotation marks that you are representing that this is an accurate quotation of Mr. Andrews's testimony. Is that correct?
I believe it is, as the footnote reference, I think, confirmed.
And so you were quoting Mr. Andrews as stating that, quote, "The major driver of increase to the depreciation rates proposed by the company," the term proposed by the company is in brackets, "is the growth of investment held in utility property over the last 10 years." That's correct. That's what's written there.
Yes.
Okay. As you said, there's a footnote reference to page 14, lines 3 to 4 of Mr. Andrews's direct testimony. Can you please pull up that reference in Mr. Andrews's direct testimony?
I said that was page 14, correct?
Yes, that is correct.
I have that.
Okay, starting at line 3, do you see that he does not say the major driver? He says a major driver, correct?
I will accept that correction.
And you agree that those aren't the same thing?
Well, I think the import is the same, but yes.
So going on to the further parts of the quote, you quote Mr. Andrews as saying, "the major driver of the increase to the depreciation rates." But what's written in Mr. Andrews's direct testimony is a major driver of the increase to the depreciation rates and expense. Is that correct?
That is correct, and I would stand by my answer, though, whether it's a or the.
But would you agree that depreciation rates and expense are not the same thing?
Oh, certainly.
Now I'm going to the last part of the quote from Mr. Andrews. He attributed the increase to the depreciation rates and expense to the growth of investment held in utility property over the last 10 years, correct?
Correct.
Would you agree with Mr. Andrews that the growth of investment held in utility property over the last 10 years has driven the increase to the depreciation rates and expense?
Well, certainly to the extent that plant investment has increased, the depreciation expense is going to increase. The point I'm trying to make here is that the comparison that's contained in my exhibit and in my testimony has the same plant investment in it. So when we're looking at the percentage change in either expense or the change in the rate, it's applied to the same base. That's the point I'm trying to make here. I don't want to be deceptive that what I'm doing is, again, making a comparison is a 10-year comparison. It's not.
So I would say you are speaking about your direct testimony. So I will direct you back to your direct testimony. If you could get that up and turn to page 2 and let me know when you're there.
I have that.
Okay, so starting at line 17 through 22, you say the 2024 increase in rates and accruals is largely attributable to 3 things. Do you see that?
Yes.
And what do you say is the third thing, if you could read that to me?
The increase in the rates and accruals. Yes, it also says it was an 80% jurisdictional plan investment. Again, the point I was trying to make is when we're comparing current and proposed, they're both applied to the same plan.
No,
if we want to say the expense and the rates have increased over the last X number of years, that's true, and it's attributable to what we said. But, excuse me.
I apologize. Go ahead. Sorry, were you finished, Dr. White?
Yes. Again, I emphasize the point I was making is that the difference that we're comparing between current and proposed is not a function of the growth. That was the point.
So I do want to ask you a few questions about the growth and investment that you are referring to here. So if you would get up your rebuttal testimony again and turn to page 12 and let me know when you're there.
I have that.
So starting at line 10, you explained that you are recommending retaining a 55R4 life curve for account 376.20, which is the account for plastic means. Is that correct?
Excuse me, I don't think I'm on the same page as you. What page are we on?
Page 12 of your rebuttal testimony.
Okay, I'm there.
And at line 10?
At line 10?
Yeah, so I have at line 10, it's a question, why did Foster Associates recommend retaining a 55R4? This is your rebuttal testimony.
Yeah, that's interesting because that question of mine is on line 5. So I can follow you, I'm sure.
Okay. So now that we have found that, you are recommending retaining the life curve, retaining a 55R4 life curve for account 376.20, which is the account for plastic means, correct?
That is correct.
And that life curve was approved by this commission in formal case 1137, correct?
Which would have been, I believe, the 2015 study, yes.
And they did that based on your uncontested recommendation in that 2015 study, correct?
I believe that's correct.
Okay, if you could turn to what has been pre-marked as OPC Cross Exhibit 12. This is the transcript of the evidentiary hearing in formal case FC1137.
One moment, I'll try to bring that up. And what page would that be in the document?
In the PDF, I am not sure.
And which question is it?
Sorry, what was the?
I'm sorry, which exhibit is it?
12, please.
Moment of the commission's indulgence, and I will direct Dr. White to the PDF, the page in that PDF. Apologies as I'm scrolling.
And what is that, please?
Okay, Dr. White, within the cross exhibits PDF, OPC cross exhibit would start on page 1040 of 1537.
All right, I'm on page 1040.
Okay, so you can see that this is the first page. The first page of this exhibit, the one that you should be looking at, shows that it's the transcript of the evidentiary hearing in formal case 1137.
And it was October of 2016, I believe?
Yes, that's correct.
Okay.
I am going to ask you to turn to page 1244, and I'm using the pages that are in the upper right hand of the transcript.
Okay, bear with me 1 second. I'm there.
Okay, so beginning at line 12, you should see that then Commissioner Dottie Fort asks you a question about how you accounted for the accelerated pipeline program that is taking place. Do you see that?
Yes, this way and taking it out. Yes, I see that.
Okay, and then following that, at lines 15 to 16, you responded that there was no consideration given to that. Do you see that?
I do.
Okay, can you turn to the next page, which would be page 1245?
Okay, I'm just looking at the remainder of that response.
Just
And
let me
again,
know
it
when you're
goes
on.
to the type of pipe. All right, please, the next a reference to me?
Was page 1245, which should be the next page.
I'm there.
Okay. I am focused on lines 11 through 17.
Yeah.
So Chair Kane asks if you were aware that the accelerated pipeline program is replacing cast iron with pipe of a material that is going to last longer. Do you see that?
I see that.
Okay. I would ask that you turn the page again to page
Yeah.
1246.
Yes,
Starting at line 1, you respond that you are aware of that and you understand that plastic is going to be installed. Do you see that?
I do.
Okay, I'm going to ask that you turn the page again to page 1247.
Yes,
Chair Kane asks a clarifying question here. I would ask that you read page 1247, line 18 through page 1248, line 22, and let me know when you are done.
I read that.
Okay, I'm going to paraphrase a little bit here because there's some crosstalk shown in this portion of the transcript. But the gist of this back and forth is that Chair Kane asks if you took the plastic installations into account and you say you did not. Is that correct?
I thought he was talking about the program in the prior. The testimony speaks for itself. I'm now addressing plastic, I believe.
Sorry, can you repeat that last part again, Dr. White?
I said I was referencing back to the initial portion of the conversation, and now we're talking specifically. I just lost my place here. I'm sorry. I'm on line 1. To the questions you're asking right now.
The question I'm asking now is focused on page 1247, line 18 to page 1248, line 22.
Okay. And there I talked for some time with us and going different going forward. I'm with you. I'm sorry if I've messed up your line of questioning.
No, that's okay. I am going to ask you my last question again, though, just so I am clear. The gist of the back and forth in these lines is that Chair Kane asks if you took the plastic installations into account and you say you did not. Is that correct?
Probably not with respect to the plastic, because we were replacing plastic with plastic. And I'm trying to confirm with myself that that's where we're at in the discussion. Are there forces of retirement that are acting upon this plastic that are acting to be different from the forces of retirement that I observed from the existing? And I said, plastic? And he said, yes. So now I'm talking about plastic to plastic. As I read this, you can correct me if I'm wrong.
So the way that I read it, if I could focus you at 1248, line 4, Chair Kane said that the plastic is one part of the equation. And you say that the dollar value goes to the depreciation expense. That's at line 7 through 8. And then Chair Kane asks whether you took that into account, and you say you didn't.
I'm afraid you're losing me now. I'm back to line 18 on 1247.
Yes, which you were talking here about the forces of retirement, and they are acting on plastic.
Yes, relative to the plastic that we've already installed.
Right.
Okay, and that's when I responded that I saw no reason to think there's going to be differences in the forces of retirement on the plastic that is being installed to replace the cast iron than what I had observed on plastic in the past.
Yeah, and so I will now direct you to page 1248, lines 16 through 19, where you explain why you didn't do that. And it is why you did not take the installations into account in your 2015 depreciation study, which you did not do because it was based upon year-end 2014, and there's no forecast of expenditures, either additions or retirements, correct?
Correct.
Okay. So now I want to talk about account 380.20. If you could turn to page 13 of your rebuttal testimony and let me know when you're there.
So you said page 18?
Page 13.
13.
I am there.
So starting at line 6, you're asked why you recommended retaining a 55L2 projection life curve for account 380.20. Do you see that?
I see that.
You respond that the above explanation regarding account 376.20 is equally applicable to account 380.20. That explanation is the immediately preceding response starting on page 12 at line 12, correct?
I think it goes back much further than that. It goes back to all of the leading in discussion about service life analysis, probability theory, and that eventually focused down to the mains account. And so we can't just take the one comment. I think we have to look at it in the context of the whole testimony.
So if I could direct you back to page 13.
Yes.
At line 6, the question you're asked is why did Foster Associates recommend retaining a 55L2 projection life curve for account 380.20? And you respond the above explanation. So I am referring to the immediately above question, which asks why you recommended retaining a 55R4 projection life curve for account 376.20.
I'm with you on that, but I would still say that that response to mains was predicated on everything that preceded it.
I see what you mean.
In the end, I had already discussed limitations to the data, high degrees of censoring, conformance index, and all the things I had discussed about statistics. So I don't want to narrow this down to, well, the comparison is the same between means and past. What I'm talking about is the estimation of life statistics and how I came to the conclusion that I was recommended retaining the existing projection lines and curves.
So I understand what you're saying, which I believe is that the previous question is one part of the explanation for retaining the life curve for account 380.20. Is that accurate?
That's accurate.
Okay. So if we could look at page 12, lines 19 through 22. So at least part of your explanation is that the data is insufficient to recommend an adjustment to the commission-approved parameter, correct?
I'm on line 19, I believe. Oh, I
I
think we determined we have a different line number.
This is the small paragraph on that page, as long as we are on similar pages and are off by a few lines.
And how did that paragraph begin, please?
It is the opinion of Foster Associates.
I'm with you.
Okay. So you say that at least one of the explanations for retaining the life is that the data is insufficient to recommend an adjustment to the commission-approved parameter, correct?
Yes, I'm discussing censoring.
Yes. And just to clarify, the commission-approved service life for account 380.20 is a 55L2 curve, correct?
The curve that, the projection life and curve that was approved in the 2015 study, correct?
Yes, and that's the one you're recommending retaining in this formal case 1180, correct?
That is correct.
Okay, I'm going to ask that you turn to what has been identified as OPC Cross Exhibit number 13. This is Commission Order number 17132 in formal case 1093.
I had written down someplace the page numbers in there, and of course I misplaced it. So
Dr.
if my
White,
counsel can tell me the page.
I will direct you to page 1115 of the OPC cross exhibit packet. That should be the first page for the referenced order.
Would you give me that again, please?
1115.
I believe I'm there. It's the opinion in order.
You see opinion number 17132, correct?
Yes, I do.
Okay. So if you would turn to page 45, and I am also referring to the page numbers that are at the top right of the documents here.
I have that.
So paragraph 104, the commission finds that OPC's recommended lives and curves fit the actual data better than WGL's. Do you see that?
Oh, that's what it says, yes.
Sorry, I didn't catch that.
Yes. Mhm.
Okay. If you could now turn to page 41.
Yes.
At footnote 232, the commission notes what OPC's recommended service lives for those contested accounts are. For account 380.20, it says OPC recommends a 55-year service life as opposed to WGL's 45 years. Do you see that?
I'm not disagreeing with you. I don't see the footnote. The number is which?
It's footnote 232. On page 41, if that helps.
I best get on the right page. Okay, there I am. 232. Relying on industry statistics. OPC finds. That's quite different from the analysis, but that's okay. I see the footnote.
And you see that OPC recommends a 55-year service life as opposed to WGL's 45 years, correct? It's about midway through the footnote.
Yes, I see that. And the preface to all of that was industry statistics as well as was misplaced a retirement rate method. I see that. That's what it says.
Okay, so this is a commission order in formal case 1093. The depreciation study that you performed in formal case 1093 was based on plant data through 2009. Is that correct?
That is correct.
Now I want you to turn to your rebuttal testimony in formal case 1162, which has been identified as OPC cross exhibit 6.
And help with the page number, please.
One moment, Dr. White.
I think I just found my cheat sheet. Is that 347?
Yes.
Yes, it is.
I have it. Thank you.
Can you turn to page 11 in this document?
And they're numbered at the bottom now, correct?
Yes, correct.
Okay, I'm there.
Can you review lines 28 to 35 on this page, then continue to page 12 and read through line 14 and just let me know when you're finished?
Well, start over with me. You want me to read from line 20?
28, please.
Oh, I'm sorry. That was the question.
Yes, correct.
Okay.
And then just read through to the next question over on page 12, which ends at line 14.
I see that.
This describes your formal case 1137 service life recommendation for account 380.20, correct?
Yes.
And in FC 1137, you recommended retaining the 55 L2 curve ordered by the commission in formal case 1093, correct?
I believe that's correct. If I can keep the case numbers straight, yes.
And your recommendation in formal case 1137 was uncontested, is that correct?
1137.
Yes.
That was.
I can refer
that was
you.
the 2015 study, yes.
Yes, correct. But in FC 1162, which is the rebuttal testimony that you are looking at here, you did propose a change to the service life for account 380.20, correct?
It would appear to be the case.
You proposed to lengthen the service life from 55 years to 60 years, is that correct?
That is correct, but I believe that you may have to correct me on this. I believe that they retained the then current parameters, despite my recommendation. You may correct me on that.
Or if you will accept subject to check, formal case 1162 was settled and they did retain the depreciation rates in formal case 1137.
Yes, that was my recollection.
But I do want to talk about why you increased the service life in FC 1162. So you say in your rebuttal testimony that I've quoted to you here, you considered it appropriate to move the service lives in the direction of the changes observed between the 2015 and 2019 studies. Is that correct?
That is correct. Appears to be correct, yes.
Okay. I know we've gone through a lot of history here, but I just want to make sure I have it clear. So for account 380.20 in formal case 1093, the commission selected the 55 L2 curve recommended by OPC. That's correct?
Run that by me one more time, please.
In formal case 1093, the commission selected the 55 L2 curve that was recommended by OPC.
In 1093?
Yes, that was the order that we looked at with the footnote.
Well, 1093 was a 2010 study.
Correct.
Okay.
And in that case, the commission found that OPC's recommended 55-year service life was the appropriate service life as opposed to the 45-year service life you recommended in that 2000 study. Is that correct?
I guess the order speaks for itself, yes.
And then you recommended that curve, the 55-year curve, be retained in formal case 1137. Is that correct?
And 1137 was the 2015 study, correct.
And you recommended a longer service life in formal case 1162, correct?
And 1162 was the 2019 study.
Correct.
Correct?
That's correct.
Yes.
And it was specifically a 60 R2 curve, correct?
Yes.
And here in formal case 1180, you are recommending the 55 L2 curve, which was first proposed in formal case 1093 by OPC. Is that correct?
That is correct. And we can certainly go down this path, but then we're going to get into the weeds on the statistical analysis itself, degrees of censoring and so forth and so on. But I certainly agree with you that I'm recommending retaining the 55.
I will tell you that was the last of my line of questions on that. I do have one more line of questions to ask you. So I don't think we need to get into the weeds at this point. If you would turn to your rebuttal testimony and bring up page 7 and let me know when you're there.
I am there.
So I am starting on line 23, which is the question. I don't know what line you have, but I have line
That
23.
is what I have. Are there other reasons? Yes.
Yes. So you're asked about other reasons to prefer your statistical techniques to the curve fitting used by witness Andrews. Do you see that?
I do.
And you respond that your techniques overcome a chaining problem when fitting a curve to observe proportions surviving. Is that correct?
That's correct.
Problem, you say, is that one or more anomalous or irregular retirements will dictate the value of points plotted for subsequent age intervals, correct?
That's correct.
So if a natural disaster were to damage and require replacement of relatively new equipment, that would misleadingly suppress the observed proportion surviving at all later age intervals. Do I have that right?
Objection vague and also lacking foundation. Are we referring to a specific natural disaster that's impacting this account?
It's just a hypothetical question about what Dr. White means by a chaining problem, which is in his testimony.
I will then also make the objection with respect to speculation.
To the extent that Dr. White can just provide some additional clarity as to his basis for his opinion here would be helpful.
To the extent that I understood your question, I believe it made an assumption of an extreme event, which would perhaps be considered an unusual. In which case, that would depend on how that event was coded in the analysis of net salvage. If in fact it was extraordinary, it would not have affected the statistical life analysis. So it depends on the nature of the event that you're describing to me.
Can you describe an event that would dictate the values of points plotted for subsequent age intervals?
Oh, any variability in the retirements. I mean, they're up and down, and what we have is an irregular set of observed proportions surviving when we're looking at the survivor curve. And that's why I prefer to work with what's called the hazard function, which is conditional probabilities of retirement, because they are independent of one another. And as I pointed out in my testimony or in my exhibit, and I don't want to get into the weeds with you here, but the covariance is asymptotically 0. But the fact is those points are largely independent. I don't have this chaining effect that's being observed when we try to graduate the observed proportion surviving.
Just to be clear, though, in your testimony, you are talking about anomalous or irregular retirements, not non-retirements. Is that accurate?
Well, that's an example of something that could produce it. But again, I want to emphasize the independence of retirement ratios versus proportion surviving. That's
so. What you're saying is that there could be anomalous non-retirements that feed into this chaining problem that you were discussing?
No, an anomalous retirement would also be recognized in the conditional probabilities of retirement. And that's why my detailed coding provides that kind of functionality to be able to address those kinds of concerns.
Your coding addresses anomalous retirements?
Yes, it does.
And that is in the actual data that you provided to OPC?
That is correct.
Okay, thank you. 1 minute to confer.
Yes.
That's all OPC has. Thank you.
Thank you. Okay. DC government.
Hello, Dr. White.
Good
I-
afternoon.
Good afternoon. I will redirect you back to your rebuttal testimony, page 12. And if you could look
I
at,
have that.
if you could look at line 23, I believe your lines may be slightly different from the copy that I have, but the paragraph starts with more important is the need.
I'm on page 12. And I believe you wanted me in my rebuttal.
Yes, your rebuttal testimony.
Oh, which begins with perhaps more important.
More important is the need to recognize.
I'm with you.
So I'll read that aloud. More important is the need to recognize that the relevant service life for developing depreciation rates is economic life, i.e. the time period over which an asset or group of assets generate net revenue. Growing concerns, e.g. stranded investments and the environment, as well as uncertainties over the future of the natural gas industry, shift the focus from life analysis to life estimation. Did I read that correctly?
You did.
Now, these growing concerns that you reference, are they concerns from Washington Gas?
Yes, I would assume they're certainly concerned about greenhouse gases, I'm sorry, and the types of things that I discussed here. I didn't discuss those specifically with them, but it's my awareness that the economic life of gas distribution facilities is likely to be impacted by these types of events.
Okay, I'll continue to read on the rest of that paragraph after that sentence.
Yes.
These currently non-quantifiable concerns will These currently non-quantifiable concerns will ultimately dictate the economic life expectancy of plant and equipment used to provide utility services. It is the opinion of Foster Associates that now is not the time to intentionally lengthen service lives to reduce depreciation rates and shift the burden of capital recovery to future generations of taxpayers. Uncertainties regarding the remaining economic life of gas utility properties further supports retaining currently approved projection life/curves. Did I read that correctly?
I believe you did.
So according to your testimony, there are certain non-quantifiable concerns that dictate the economic life expectancy of an asset, correct?
That is correct.
And one of those non-quantifiable concerns is the risk of stranded investments.
Yes.
How would those investments that you refer to become stranded?
They can become stranded if, in fact, let's take, for example, the initiatives addressing greenhouse gases. And one of those initiatives is to reduce the amount of gases can be consumed. In other words, hooking up new customers or other efforts to diminish the amount of gas, the amount of greenhouse gases that are being emitted into the atmosphere. If that happens, that sort of initiates a downward spiral, in my view. We're going to have fewer customers to pay for the revenue requirements, but we still have all these fixed costs, and they still have to be recovered. And that's going to perhaps further exacerbate customers that are going to be shifting to some alternative energy source. And the longer that happens, then the fewer customers we have, or potentially have, is a downward spiral that's going to affect the economic life. But it's also going to affect the timing of that cash flow. And so as we start to think about the implications of events like reduction of greenhouse gases, in my view, we also have to think not only about the life, but the timing of when that decline in the net revenue stream could or is likely to occur. And so in my view, addressing those kind of concerns goes way beyond just looking at a service life as the remedy to the potential for declining net revenue. I think we need to think seriously about the net revenue itself, the patterning and timing, and all of that results in a consideration of the economic life.
The spiral that you refer to, would you say that this is potentially a death spiral, a threat to the life of the company?
Objection, scope, and relevance.
So moving on to one of the non-quantifiable concerns that you named in your testimony, you mentioned that the environment is a concern. Why should the environment be considered in the development of these depreciation rates?
Well, I thought that was what I just discussed with you. What is likely to happen in the atmosphere but that's what I had in mind when I said environment.
Are there any other environmental concerns that you think can affect the life estimation or economic life of assets?
Probably if I thought about it, I would come up with something, but right off the top of my head, no, I have not thought about that.
So when developing depreciation rates, you would choose to consider the risk of stranded assets, correct?
I consider the possibility, the potential, and as I've said in my testimony, it's too early and to attempt to quantify that. I do know that that is a concern of Washington Gas. It's a concern of every gas utility. But quantifying it is something else. All I'm suggesting here is an awareness of that possibility. And in my view, now is not the time to increase or kick the can down the road of depreciation expense when we're facing those kinds of headwinds.
So would you say that it's prudent to consider these non-quantifiable concerns, i.e. the risk of stranded assets, the environment, and the future of the natural gas industry when developing an appropriate depreciation rate?
Objection, scope, relevance calls for a legal and a policy conclusion, specifically with respect to prudency.
Sorry, can you repeat the question for me?
So would you say it is prudent to consider the risk of stranded assets, the environment, and the future of the natural gas industry when developing an appropriate depreciation rate?
Objection to the use, objection sustained as to the use of the word prudent. But if you can use a word like a factor in.
Okay, I can reword that. So you think it's important to factor the risk of stranded assets, the environment, and the future of the natural gas industry to develop an appropriate depreciation rate?
The short answer is yes. I want to clarify that yes, though. What we're talking about here in the context of the way the commission had structured the issues, we were talking about life analysis, and that's the statistical side. When we start talking about these concerns, that gets into life estimation. And yes, I absolutely believe that we need to be aware of these factors and consider these factors and the impact that they might have on the adjustments that we would make from a statistical analysis. It's one of the factors that we have to think about whether or not forces of retirement in the future are going to be similar or comparable to those that we've observed in the past. And the type of factors that we just talked about, I think, are important to recognize that they are going to be forces of retirement, and also the pattern and timing of the net cash flow different from what we've observed in the past.
So would you say that all of the factors mentioned prior are important for considering depreciation, but also other investments?
Objection, scope, and relevance, and also not just the scope and relevance that I stated at the beginning, but this is an expert on depreciation. He's speaking to depreciation. This is outside the scope of his specific testimony.
Sustained.
We have no further questions.
Thank you. Sierra Club?
No questions, Mr. Chairman.
Oh, okay. Any redirect?
Briefly, Your Honor. Dr. White, you recall the questioning that you just received from counsel for DCG with respect to the passage on page 12, line 23 through page 13, line 5 of your rebuttal testimony. Don't you?
Yes, I was.
And is it your position that at this time, the concerns you were discussing are quantifiable or non-quantifiable?
They're non-quantifiable, but they're concerns that, in my view, we certainly have to recognize are going to impact whether or not the retirements and net cash flows that we observed in past are a good predictor of the future. And I can't quantify them at this point, but they're on the horizon and very quickly.
And you specifically state that it is not now is not the time to intentionally lengthen service lives. Did I read that correctly?
You did.
And was that in specific response to the recommendation of another witness who advanced the theory that these service lives should be extended?
Yes.
No further questions.
Thank you. At this time, the commission moves PSC exhibits 22 and 41 into the evidentiary record.
Your Honor, if I may clarify, our cross exhibits were pre-filed and I do not need to move those into the record because I did not refer to extra exhibits. Is that accurate?
I think that's fine, yes, because you primarily relied upon your witness Andrews, as well as his testimony as well. That's already in the record, correct?
I would say the cross exhibits were previous testimonies of Dr. White's, yeah.
Yeah, okay, thank you.
Thank you.
Okay. My watch shows 2:13. Let's have a brief lunch and come back here at 2:45, and we will pick up with Mr. Morrow from Washington Gas. Thank you.
Mr. Chairman, 1 second. I apologize. So I'm seeing in the cross-examination matrix that, or at least from the note, that OPC has agreed to waive cross-examination of witness Morrow. Is that correct? And that Sierra Club, it indicates slight cross-examination for witness Morrow. So we actually do not have questions for witness Morrow, so I don't want, if that will allow witness Morrow to not wait around. I just wanted to mention that for everyone's convenience.
Okay. I'll rule on that after the lunch, but thank you for making me aware of that. Thank you.
Testing 1, 2.
Thank you. I hope everybody enjoyed their lunch. Prior to taking a recess for lunch, we had representations from OPC and Sierra Club regarding witness Morrow. I do still want to call him and have him live, and then we'll take care of a few administrative things. So if we could have witness Morrow, please come to the stand. Thank you, sir.
Hi, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth? Thank you. Please be seated.
Thank you, witness Morrow. I believe Commissioner Trabue has a question for you.
And the question may actually be to counsel, to Office of People's Counsel. I understand that Sierra Club has no questions here, and is this still a contested issue?
If I may, Kevin Conoscenti, on behalf of the Office of People's Counsel.
Speak up, I can't hear.
Sure.
Is
Yeah.
the mic on?
I think so. Can you hear me okay now?
Here we go.
Yeah, the issue is still contested. The office and WGL came to a agreement to mutually waive cross-examination on the issue. That was witness Morrow and OPC witness Fitzhenry, and we agreed to waive cross-examination without getting into attorney-client communications or privileged communications. I would just note that the value of the issue that was set for hearing was fairly modest, and we agreed in, at least from my perspective, administrative efficiency was best to waive cross on this specific issue.
I sincerely appreciate your response and your understanding of administrative efficiency in moving this forward. Thank you very much.
And then just one follow-up question on that. One, thank you for that answer as well. I believe Mr. Murphy's also a witness on this issue as well. Is that testimony still needed from witness Murphy?
I'm sorry, could you repeat the
Sorry, it's
question?
my understanding that witness Murphy is also a witness on this issue, or is he going to be speaking on, or are they going to be speaking on a different issue?
To my knowledge, he's not speaking on this specific issue.
So-
Just here, yeah.
And if I could, Chairman, witness Murphy was amongst those that had been designated by certain of the parties. Certainly, I think that we all have heard me say this enough times. I have disputes with respect to scope and relevance of some of this cross, but DCG and Sierra Club have indicated that they have cross for him today. So he is available.
Okay, just wanted to make sure that we had everything in terms of witnesses and we could excuse the ones that weren't necessary. But for the record, witness Morrow and witness Fitzhenry will not be testifying.
That's my understanding, is that WGL does not have any questions for.
I have no questions for OPC witness Fitzhenry.
Okay, thank you.
Mr. Chairman, in regards to witness Murphy, I also want to represent that although it indicates slight cross in light of proceeding today, we no longer have cross for Mr. Murphy, but I can't speak for DCG.
Okay.
Still indicated they have slight cross for Mr. Murphy.
Thank you for that update.
Just one more note. I did want to note that the order, the issue that was set for hearing, that it clearly concerns PG County regulations. There's several references in the order to project pipes, but we understand that the issue that was set for hearing was the project ILI readiness strip 24 launcher. So just to be clear, that was the basis for our waiver, was the narrow issue that was set for hearing. So we don't view that as a project pipes question.
Okay, that's fine.
And just to point out, we did raise certain project pipes issues, which we asked to have set for hearing, but they were not. So
correct.
yeah.
Okay. All right. Having taken care of that, before our excused witness tomorrow, I'd just like to note that the commission now moves PSC exhibits 1 through 6 and number 52 into the evidentiary record at this time. And there being nothing further, witness tomorrow, you're excused.
Thank you, Your Honor.
At this time, we'll proceed forward with witness Quinum. Did I say it correctly? Quinum, okay.
Hi, can you please raise your right hand, please? Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth? Thank you. Please be seated.
Ms. Francis, floor is yours. Ms. Francis, can you move the, thank you.
I'm going to start by asking you to refer to your direct testimony, WGJ1. Am I correct that you presented Washington Gas's Cost Allocation Manual, or CAM, in Exhibit WGJ-1, which was the public and the confidential version of Washington Gas Exhibit J-2?
The witness's mic might not be on.
Yeah, I can't hear her.
I present.
Okay. Okay.
Sorry about that. So I presented Exhibit WG J-1 as the public version of the CAM, the Cost Allocation Manual, and WG J-2, which is the confidential version.
Thank you. Now, first, I would like to walk you through a few dates. The CAM presented in Exhibit J-1 was filed on April 30th, 2024, correct?
That is correct, yes.
And that CAM is based on the 12 months ended December 31, 2023, correct?
That is correct.
The test year in the company's application is the 12 months ending March 31, 2024, correct?
That is correct.
Now, please turn to page, excuse me, 26 of the CAM presented in WG J-1. Tell me when you're ready.
Page 26.
Correct.
I am
there?
there. Yes.
Okay. Does the organizational chart presented on this page represent all entities that Washington Gas provides services to or receives services from?
I will say yes.
On this page, there are two footnotes. One has a single star and one has a double star at the bottom of the page. Do you see that?
I do.
And the first footnote, and I'm going to quote it because the print is very small, states that the organizational chart on this page, quote, primarily reflects only affiliates that have service agreements with Washington Gas Light Company, end quote. Can you identify for me on this chart which affiliates do not have service agreements with Washington Gas Light Company?
The notes specify that this chart, and I read, primarily reflect only affiliates that have service agreement with Washington Gas.
All of these on this page have service agreements. Is that what you said?
I believe so.
Sorry.
I believe so.
Thank you. Are there affiliates not included in this chart from which Washington Gas Light Company either provides services to or receives services from?
Subject to further checking, I will say no.
So there are affiliates that are not included in this chart?
The affiliates on this chart are those that have service agreement with Washington Gas.
But are there affiliates that are not on this chart from which Washington Gas Lights either provides services to or receives services from?
I don't think so.
Does Washington Gas provide services to or receive services from affiliates not covered by the list of service agreements found on page 24 of Exhibit WGJ-1?
I am on page 24. Would you please repeat your question?
Certainly. Does Washington Gas provide services to or receive services from affiliates not covered by the list of service agreements found on page 24 of Exhibit WGJ-1?
All the affiliates on this page do have service agreement with Washington Gas.
Are there any that are not on this page?
Yes. This service agreement, as listed as of March 31, 2024, if we want to address specifically any service agreement in effect as of the date of the application for this rate proceeding, this list does include all the affiliates. If we're talking about current status for any additional entities that may have been added to the ASUS family, then the service agreements, this list here needs to be updated, but it will be as of today's date, if you wish.
I just want to make sure I understand you correctly. So the list on this page is all of the service agreements and the affiliates through the end of the test year. But
Yes,
now I'm getting
as of the test year.
But there could be other, are you suggesting that there could be others which will be in effect, other service agreements which will be in effect during the rate effective period, which will be after March 31, 2024?
If there are any additions, yes, they could be.
But are they listed anywhere in your testimony?
They will not be in my testimony because my testimony is covering the tax period, which is April 1st, 2023 to March 31st, 2024.
But the company is in its application requesting that rates be effective through the rate effective period. And I believe they have some adjustments within that period, which I think at the time of the company's application, they said was from August 1st, 2024 through the next 12 months through 25. So if there are additional service agreements that were entered into after March 31, 2024, would they be any place in the Washington Gas testimony in this proceeding?
During discovery, we did not receive any such question. I'm sure if we had received that question, we will supply the information then.
Now, let's look back at page 26. And the first footnote also states, again, I'm going to read it because it's very small. Note that Mountain View Property Management and Seaside Management, Inc. have both merged with Petrogas, Inc. effective December 18th, 2023. Do you see that?
I do.
Was this corporate reorganization reflected in the affiliate transaction allocations for the first quarter of 2024, which is the last 3 months of the test year?
Allocations will only reflect the affiliates that actually have services with Washington Gas. I can rephrase that. Allocations will only reflect those affiliates that receive any form of services from Washington Gas. If Mountain View and Seaside Management did not receive any services or any employees of Washington Gas did not perform any work that benefited these two affiliates, then they will not be part of the allocations.
Okay. I'm focus on the dates with this question. Okay. And they spoke about Mountain View merging with Petrogas effective December 18th, 2023.
That is correct.
Right. Now, this chart on page 26 goes through March 31st, 2024.
That is correct.
I'm asking you, does the reorganization the corporate reorganization that we just discussed, is that reflected in the affiliate transaction amounts for the first quarter of 2024, which is the last 3 months of the test year?
I'd like to clarify that the service agreement does give the affiliates with which Washington Gas may have affiliate transactions. It does not mean necessarily that all the affiliates should have any transactions from Washington Gas. To that effect, I would like to reiterate again that Mountain View Property and Seaside Management did not receive any allocation from Washington Gas in the test year.
No allocation in the test year.
If there's no services performed by any WGL employees on behalf of these two affiliates, there would not be any transactions on the books.
Did the corporate reorganization that we just discussed change the allocation factors developed in the CAM or in the ACCOS?
Absolutely.
Are you able to tell me what specific allocation factors were impacted?
The allocation factors will be impacted if Washington Gas did provide services to the certain affiliates. The allocation factors are dependent on the number of affiliates to which Washington Gas provided service to. I cannot speak to any specific example, but if you do have any affiliate that you wish to discuss, I am open to do that.
Well, I was specifically discussing Petrogas. So can you tell me, were there specific allocation factors, or what specific allocation factors were impacted when Mountain View Property Management and Seaside Management merged with Petrogas?
If I may ask, what do you mean by allocation factors?
Well, you discuss allocation factors in your testimony, so I'm using it the same way that you used it. I mean, you talk about the modified Massachusetts allocation factor. You're the one who testified in regard to allocation factors. So I'm asking you, what specific allocation factors were impacted by that change in corporate structure?
Allocation factors are calculated based upon the entities that Washington Gas provided service to. If you pick a specific allocation, we can discuss, but in general terms, I'm not sure how to answer that question.
Okay, let's move on and go to page 37. And I'm still looking at J1. Page 37 of exhibit WGJ-1. Are you there?
I am.
Okay. In the second paragraph of the page titled at the top, Washington Gas General Allocation Methodology. Do you see that?
Yes, I do.
Okay. That states, quote, Washington Gas allocates most of these costs to affiliates using the Massachusetts Modified Mass, MMF, is calculated using three factors: adjusted for net revenue, direct and assigned labor, and average invested capital, end quote. Do you see that?
I do.
Can you confirm that Massachusetts Modified Mass, MMF, should be Modified Massachusetts Formula, MMF?
That is correct, yes. Modified Massachusetts formula, MMF.
Okay. So the correct use of the term is Modified Massachusetts Formula, MMF, correct?
Correct, yes.
Okay. The above statement identifies that, quote, most of these costs are allocated using the MMF. Can you provide what percentage of the total costs are allocated using the MMF?
I cannot.
Is it reasonable to allocate the majority of these costs using the MMF?
The majority of we cannot, if we may turn to page, if you wish. I'd like to turn to exit section 2.
I'm sorry, where?
One second, please. I'd like to turn to section 2, of Exhibit WGG-1.
What page?
That would be page 1. No, page 5, please.
And on page 5, that's entitled Cost Assignment and Allocation Objectives. Is that what you're referring to?
That is correct. And I would like to read on the general approach, the second paragraph. It is the policy of Washington Gas and all its affiliates that costs will be directly assigned to the appropriate affiliates whenever reasonably possible, and that such costs will be allocated whenever direct assignment is not reasonably possible. Direct costs that benefit an affiliate are assigned and billed directly to the appropriate affiliate. For common services, tracking direct costs is not reasonable because one or more affiliates benefit from the expenditures. In such cases, these direct costs are allocated based on an appropriate allocation factor described herein. Where appropriate, indirect costs are allocated based on the assignment or allocation of the related direct costs. In the general intent, it is the general intent to allocate operational costs to operational affiliates rather than holding companies. I read that paragraph just to clarify that not all costs are assigned or allocated based on the MMF, only those that are impractical to direct assign go through the allocation with the MMF.
I understand the company would prefer to directly assign. I understand that's the company's position. But you and I discussed what you said on page 37 of Exhibit WGJ1, where you said Washington Gas allocates most of these costs to affiliates using the Massachusetts modified mass. And that's calculated using 3 factors. We discussed those: adjusted for net revenue, direct and assigned labor, and average invested capital. We discussed that earlier. So now my question is it reasonable to allocate the majority of these costs using the MMF?
Object to this as vague as to the majority of these costs. Witness has distinguished between directly assigned costs and then allocable costs that are allocated to affiliates. I'd like to know which one counsel is referring to.
I am referring to the witness's statement in her testimony on page 37, where she said Washington Gas allocates most of these costs, her words, to its affiliates using the MMF. So now I'm asking you, is it reasonable to allocate the majority of these costs using the MMF?
So, Ms. Francis, I'm actually going to object on the use of the word reasonable. That calls for a legal determination. Please ask the question if, in her opinion, please rephrase the question.
In your opinion, is it appropriate to allocate the majority of these costs using the MMF?
I'm not sure I understand what you mean by majority.
Well, when you use the word, let's look back on page 37. You say most of these costs. What do you mean by most?
Maybe it will make sense to read the first paragraph first, which says, as noted in the departmental description, there are several shared service functions which by their nature benefit Washington Gas and its U.S. affiliates. Such common shared services include, but are not limited to, the consolidation of the financial result, preparation of consolidated tax return, corporate communications, and other related functions. Then the second paragraph continue to clarify or to indicate that those costs, most of those costs in the first paragraph are allocated based on the MMF.
And let's focus now on page 37 of J1. And earlier I discussed with you paragraph 2, and now we're going to look at paragraph 3. And that indicates in the middle of the paragraph that the allocations, quote, are approved by the vice president and controller, end of quote. Do you see that?
I do.
Can you tell me what current Washington Gas Light Company, the distribution utility, employee or employees are responsible for approving these allocations?
Cumulative, the document is speaking for itself as to who is responsible for for approving these charges.
Sustained.
Okay. Are the vice president and controller to which you reference in J1, third paragraph, are they employees of Washington Gas Light Company, the distribution utility?
Yes.
Is approval by the vice president and controller the basis for the reasonableness of the allocation of shared services?
Would you please repeat your question?
Is the fact that the vice president and controller approve the allocations, is that the basis for the determination by the company that the allocation of shared services is reasonable?
I'm going to object to this question as well. This is retreading the reasonableness conclusion, and also the basis is spelled out in this document for the allocation.
I understand that's what's laid out in the document and how they do it. I'm asking a different question. I can reword it. Is the fact that the vice president and controller are approving these allocations of shared services, is that the basis of your determination in your testimony as to what's appropriate to do in this case?
I would like to go to page 3 of WGJ-1. Page 3.
And that's where it says, just make sure we're looking at the same thing, purpose of manual.
That is correct.
Okay.
And I would like to read the last paragraph, which state the responsibilities of the VP and controller. The CAM summarizes the procedures in place to assign or allocate shared costs. The vice president and controller of the company is responsible for implementing and maintaining processes and procedures designed to achieve the fair and equitable assignment and allocation of cost, including designing and maintaining an effective account coding structure, establishing procedures to properly code transactions such as timesheets and invoices, designing and maintaining cost allocation processes and procedures, and monitoring the result of coding and allocation processes for consistency with management intent and for compliance with the laws, rules, and regulations of the various jurisdictions within which the company operates. And I'll stop there. But I can finish the paragraph.
That's
Business
okay.
unit.
It's in testimony. You don't need to read the whole thing.
Okay.
Unless you want to.
Sure.
I don't want to interrupt you.
Okay. I will end the paragraph then. Business unit managers are charged with the responsibility for compliance with these procedures and for accurate coding of transactions and time by their respective personnel.
Now, can we turn to page 6, please, of your J1? And on this page, I'd like you to focus on footnote 4. And footnote 4 states, costs for corporate services are allocated to AltaGas business units and subsidiaries using a modified Massachusetts formula, MMF. AltaGas's MMF uses 3 factors: 1, EBITDA, 2, payroll, and 3, property, net plant, property, and equipment, including construction work in progress, materials, and inventories. Correct?
I'm going to object to this question. This is going outside the scope and to irrelevant issues set for the hearing. The footnote itself is referring for inbound services from Washington Gas's affiliates to Washington Gas. It is not dealing with the services that Washington Gas provides to its affiliates or the charges for those services.
Your Honor, I will tie.
I'm going to give a little latitude. Go ahead, Ms. Francis.
Is that what the footnote says?
That's what he said.
Thank you. Now, am I correct that AltaGas's MMF uses different factors or inputs than the MMF utilized by Washington Gas Light Company?
That is correct, yes.
Now, let's move to your direct testimony, WJG, page 6. And I'm focused on lines 5 through 12. These lines indicate that Washington Gas Light Company utilizes the PeopleSoft financial system, correct?
That is correct, yes.
Am I correct that the PeopleSoft financial system is a software product?
It is. It's a software, yes.
Thank you. Do you personally use the PeopleSoft financial system?
I do.
Yes. Do all of Washington Gas Light Company's affiliates utilize the PeopleSoft financial system?
No.
Yes?
No.
When did Washington Gas start using the PeopleSoft financial system?
I'm not sure. I joined the company in 2017, and the company was already using PeopleSoft, but
At least,
I don't have an exact date.
so at least from 2018 onward, they were using PeopleSoft financial system.
That is correct, yes.
And do you know what was the software that PeopleSoft replaced?
I'm going to object.
I'm
to out of
sorry.
scope. Out of scope.
Sorry?
Out of scope. The witness has already testified that was prior to 2018 in her time at the company.
Do you know what was Washington Gas Light Company's decision to utilize PeopleSoft's financial system based on?
Again, out of scope. That was prior to her time at the company.
It was prior to her time, and I respect the commission's decision, but it doesn't mean that she doesn't know why the decision was made.
I'm not sure that's relevant to the material issues of fact and determination, but if the witness knows the answer to this question, she can answer.
I do not, Your Honor.
Okay, thank you.
Can you tell me, does the PeopleSoft financial system adhere to the FERC system of accounts?
Yes.
Do any of the cost pools identified in Table 1 on page 3 of J4 include costs attributable to multiple FERC accounts? And I'm going to state, Your Honor, I am not trying to get at any confidential information. If the witness feels she needs to, she or her counsel need to let me know.
Thank you for that.
And just to be clear, the reference is to Table 1 on page 3 of Exhibit WGJ4. Okay. I think we're okay if we stay within the content of that page.
Right. Do you need me to read the question?
Trying to get to WGJ-4.
I'm sorry, I can't hear you.
Could you please repeat your question?
Certainly. Do any of the cost pools identified in Table 1 on page 3 of J4 include costs attributable to multiple FERC accounts?
Yes. Yes.
Does the PeopleSoft financial system provide for the ability to track costs by each FERC account separately?
Yes. In fact, in this proceeding, we provided the FERC financial statements.
Do any of the cost pools identified in Table 1, page 3 of J4 include costs attributable to multiple FERC accounts?
Yes.
Now, do you have the packet of data request responses that AOBA has on its cross-examination exhibit list? She had the packet.
I believe that she does. Ms. Quinham, if you will just identify when you do not have one of these data responses, you should have them though.
The witness, the covered document says cross-examination exhibits of the Apartment and Office Building Association dated August 13th. Do you have that packet?
May not have the packet. She may have the data request with her. It'll be the same thing.
Okay. Now, I'd like you to turn to what has been preliminarily identified as AOBA 37, which is WGL's response to AOBA data request 3-19. Could you please take a look at that? And Your Honor, I'd like to have what was pre-marked as AOBA Exhibit 37 marked for the record as AOBA Exhibit 37.
Any objection, counsel?
No objection.
So admitted.
Tell me when you're ready.
AOBA question 3-19?
Yes. Company's response.
Yes.
Ms. Francis, I'm trying to keep up because you guys are jumping from document to document. On which page are you at the moment? I think I have the.
You have it, Commissioner? It's the fourth document on my cross-examination exhibit list.
Okay. I'm with you. I'm
Okay.
sorry. My first time at this. This is documents jump back and forth. It's hard.
There are a lot of them.
I'll find a better system next time.
I have extra paper copies if you want. No, okay.
Save trees.
Ms. Quinham, you are the answer of that data request response, correct?
I am.
In your response to AOBA data request 3-19, you used the phrase amounts the utility allocated or assigned net cost billed to from for the test year, end of quote. Do you see that?
I do.
Does the ACOSS presented in this proceeding provide the ability for the parties or the commission to calculate both the cost billed to and cost billed from Washington Gas and its affiliates independently?
Which type of costs?
At your response, and I'm reading your words, and your words say, they're citing J3, confidential appendix F, amounts the utility allocated or assigned, and then you wrote net cost billed to from for the test year, 12 months ended March 31st, 2024. My question is, does the ACOSS presented by you in this case provide the ability for the commission to calculate both the cost billed to and cost billed from Washington Gas and its affiliates independently?
What costs?
What costs are you referring to in your response? What costs? I'm referring to the same cost that you're referring to.
The appendix the confidential appendix F shows a variety of costs.
Correct.
There's labor costs, there's direct expense, there's overhead, there's some common and shared costs. So I'm not sure which specific costs you're referring to.
You are referring to net costs billed to, right? Billed to affiliates, correct?
Yes.
Net costs billed from affiliates. Because these are
Yes.
your words. Now,
Yes.
is there anything in this testimony that the company has provided that would enable me to see those two things independently? The first thing is net cost billed to affiliates that I want to see. And then the second number that I want to see is net cost billed from affiliates. I'm looking for those two different numbers. Is there anything in this ACOSS or in the testimony in this case that it would allow me to look at those numbers independently?
The Schedule F shows two sections, or maybe three. One section shows the cost allocated or assigned from Washington Gas to affiliate. Then there's another section that shows the costs allocated or assigned from affiliate to Washington Gas. Then the third section shows the net costs billed to and from. So if one would like to know how much Washington Gas, the net transactions between Washington Gas and any of the affiliates, it's already on the Schedule F.
What you're referring to, let me just get the schedule. What you're referring to are costs that are netted, correct?
No,
I'm trying to get those numbers not netted.
the
Can you,
costs are not netting. The Schedule F, and if you will turn please to Exhibit WG J2,
sorry, could you start over?
Exhibit
Could you give me that site again, please?
Exhibit WG J-2, which is the confidential version of the cost allocation manual,
Give me a minute. I'm looking at J2, correct?
Appendix F. Please let me know when you're there.
I'm there. I just need my magnifying glass. I think I'm looking at the same thing you are. But when I read the top of that page, it says amounts the utility allocated or assigned, net cost billed to from. It's the title of the page, correct?
Yes.
Okay. Those,
Ms. Francis, let me just ask a few questions here, I think, to kind of bring some clarity. Ms. Quinham, sorry. Can you just explain without going into detail around the numbers, the various divisions on this chart and what they show?
Right. Yes, Your Honor. So we have at line 1, the services. Let me say we have 2 blocks, 2 main blocks. The first block is the services provided to affiliates by Washington Gas. Then the second block will be the services provided by affiliate to Washington Gas. Then we have another line that nets the first blocks with the second to provide the net cost assigned or allocated.
So does line 48 show the total services provided to affiliates by Washington Gas? Am I reading that correct? Is that line 48 on the spreadsheet on J2?
It's line 59 if we're looking at the one ended March 31st, 2024. So at the top of the page, it will indicate it's line 59.
That's the net.
That is the net.
Okay.
If we're looking at the services provided by Washington Gas to affiliates, indeed, yes, it's line 48.
Line 48, okay.
Services provided by affiliate to Washington Gas will be line 58. And line 59 will be the net of the 2.
Okay. Does that help you, Ms. Francis?
Your Honor, I recognize that she's saying net costs, but I am trying to get at the costs before they are netted, and there's another component to that. Do they make adjustments before they net the costs, or do they make adjustments after they net the costs? I want to see the costs that are not netted. And that's what I don't see on this exhibit that she told me I would.
Okay, and please correct me if I'm wrong. I think line 48, and please witness, correct me if I'm wrong, that line 48 on that page 1 of J2 says total services provided to affiliates by Washington Gas. And then the netting comes after that. I don't want to substitute my testimony for the witnesses, so.
Your Honor, you're correct, yes.
Oh, the netting comes after that number?
After.
And let me ask this a different way. Would it be fair to say that the net is the difference between what went out and what came in? So what went out, because my screen has gone blank. What went out is probably what, line 48 or so?
48.
Okay. What came back in?
Line
is-
58.
Okay. And then the net is the result, is the balance of that. Is the net is the result of that.
I know that's what she's saying.
So
But if you wanted to look at all of those costs,
well, that should be line 1 through 48. I think what Ms. Francis is trying to find.
these are groups of costs. And if I wanted to borrow these costs, I don't know where to go to do that.
You want to verify all of them?
I want to verify each of the costs to find out, my opinion, if they're reasonable and appropriate and market value or whatever cost that I may use to see is Washington Gas getting reimbursed properly for what services it provides. That's what I'm looking for. I don't know where to see it.
I'd like to go to page. I'd like to go to page 9 of my direct testimony. So earlier we read that Washington Gas will direct charge any cost that is easily identifiable to any affiliate. So, and any other cost that is not reasonably.
I don't mean to interrupt you, just you could direct me to where you are on page 9.
So on page 9, I would like to reference from line 6 to line 16, where we provide detailed data, which includes the calculation for the MMF. We provided the calculation for all the allocations that are performed in PeopleSoft. We also provided bank information as well as PeopleSoft queries that show that Washington Gas was made whole for every services that Washington Gas rendered to the affiliate as of the test year. That documentation is included in the compliance filing, and it's about 1,200 pages. I memorized the page number from page 8792 to page 10,000 of the compliance filing. That speaks to the size of the data that we provided to show how the allocations were performed in PeopleSoft and calculated, as well as the factors used for the allocations.
This page. It says it's the PeopleSoft data that presents the amounts billed to each affiliate and amounts collected from each. I guess you mean each affiliate, correct?
Please direct me to the line again.
Line 11.
Yes.
Then again on line 13, it says PeopleSoft system data for pooled total amounts for time and later charged to affiliates. Okay. Focus back on line 11. It's amounts billed to and collected from. My understanding that the PeopleSoft software nets those two amounts and then you get a result, correct?
No.
Okay. So what goes into PeopleSoft, the inputs, we don't see, correct? Because what comes out of PeopleSoft is a netted amount, correct?
I'm not sure what you mean by netting.
PeopleSoft presents that data that presents the amounts billed to each affiliate and the amounts collected, correct?
Please allow me to further explain Appendix F to WGJ-2, if you will go back to those pages to explain what I meant by collected.
And I'm not going to focus on this too much, but this is the data where you tell me what's on this page that I can find the answer to my questions, correct?
What page?
Just didn't you refer to me to Appendix F of J2?
That is correct. And I would like to walk you through to further clarify line 11 from my direct testimony, from page 9 of my direct testimony. Please let me know when you.
To find your confidential testimony. There.
So if we go to Schedule F, on line 48, I'll go back to the explanation which I gave earlier. So line 48 shows the services provided by Washington Gas to affiliates. Line 58 shows the services provided by affiliates to Washington Gas. Line 59 shows the net services provided to and from, which will be the net amount either owed by the affiliate to Washington Gas or owed by Washington Gas to the affiliate. Line 60, 61, and 62 now shows the cash collections, what Washington Gas paid to the affiliate and what Washington Gas received to affiliate. Then compare the net receipt or the net collection to the net amount on line 59.
Just for a moment, I'm going to go back to when we were just talking about adjustments. You said you made adjustments
Adjustments?
after the amounts are netted, correct?
No.
Said before the amounts, the adjustments are made before the numbers are netted?
What adjustments? Where do you read that on my testimony, please?
I'm going to,
Sure.
I quoted the phrase from J3, amounts the utility allocated or assigned, net cost billed to from for the test year. When you get those numbers, do you make any adjustments to them?
There's no adjustments. I'm not sure what you mean by adjustment.
You never make adjustments to see if the number isn't correct, that it doesn't look right to you. You say you review everything in some place in your testimony. I don't have a line number. You're reviewing for accuracy. Do you ever make adjustments? Or what goes into PeopleSoft is what comes out. Nobody looks at the results and nobody makes an adjustment. Do you make adjustments?
We do look at what goes into PeopleSoft and we review the transactions, the affiliate transactions. But I'm not aware of the adjustment that you're referring to. If you can point me to anywhere in my testimony, we can discuss the adjustment further.
I don't want to waste the commission's time, but there is testimony here. You say you review the data, look at it, see if it's correct. And when you're reviewing the data, do you ever find an error that needs to be adjusted?
Please refer me to the line where I spoke about those adjustments.
Ms. Quinham, have you ever made adjustments to the data, either because of an error or any other reason?
If there is an error, Your Honor, yes, we will correct it.
Do you recall making an adjustment yourself?
I don't, specific to affiliate transactions, no, I don't remember. But yeah, if there's any adjustment to be made, yeah, we should.
Okay.
Now, I'm going to refer you, I found it, it's in your testimony, page 6. I'm looking at your confidential testimony, but it only refers to confidential appendix F. And you say, quote, I review all charges recording on Washington Gas and the affiliate books to ensure, 1, the charges reflected on the affiliate records are properly excluded from Washington Gas records. The cost, 2, the cost of services by Washington Gas are cash settled. I also review cash paid by Washington Gas to affiliates for services received from affiliates for accuracy and completeness. You see that?
I do.
And that's what I was addressing to ask you if you made any adjustments.
And she just answered the question.
Yes. Okay.
Thank you.
Now, do you ever make any reassignments? When I think of an adjustment, I think of you are changing an amount that is inappropriate. Now I'm asking the same questions about reassignments. Do you ever see anything that perhaps is reassigned incorrectly that you need to reassign in this review that you discuss on page 6?
A correction will encompass all that. If there's need to reassign, yeah, we would, to make the books correct, yes.
Have you ever done the reassignments?
If there's need to do so, yes.
This is my last couple of questions. Have you, in your testimonies, calculated or quantified the savings to ratepayers that are the result of Washington Gas's provision of services to specific unregulated subsidiaries of Alta Gas?
I did not.
Have you, in your testimonies, calculated or quantified the savings to ratepayers that are the result of Washington Gas's provision of services to specific unregulated subsidiaries of Washington Gas Light Holdings?
I did not.
Your Honor, I'm going to ask the witness about a couple of data request responses that are listed in cross-examination exhibit list. Ms. Grenham, earlier I referred to AOBA Exhibit 37. Now I'm going to ask you to take a quick look in the packet that you have. And I ask you to look at AOBA Exhibit 38, which is WGL's response to AOBA Data Request 320. AOBA 39, which is Washington Gas Light's response to AOBA DR 3-25. I'd like you to look at what's been preliminarily identified as AOBA 40, Washington Gas Light response to AOBA DR 3-26, and AOBA 41, which is WGL's response to AOBA data request number 3-27. And can you please look to verify that you are the sponsor of all of those data request responses?
To make sure I have the correct data request numbers, you mean 320, 325, 326, and 327. Yes, I have them.
Can you verify the accuracy of those data responses for purposes of entering them into the evidentiary record?
I'm sorry, can you repeat your question?
Verify the accuracy of those data request responses for purposes of moving them into the evidentiary record.
Yes.
Your Honor, at this time, I would like to move what has been preliminarily identified as AOBA Exhibits 37, 38, 39, 40, and 41 to the record.
Your Honor, the only objection I have here is to AOBA Exhibit 38, which is the response to data request 3-20. To the extent that that data request is going to be entered into the record, OPC DR 4-2 also needs to come in. Otherwise, this is an incomplete representation of the witness's response to this.
Okay, I also put in, if you look above, counsel, OPC data request 4-2. Okay, I just entered that. That's the same as, I'm entering that as AOBA 36.
If that is coming in as well, I have no objection.
So moved.
Your Honor, is it,
Yeah.
how do you want me to treat AOBA Exhibits 1 through 33? Do I move for their admission? Do I wait to hear from the commission? Those were filed on Tuesday. And I didn't plan on using them today.
And you are seeking to move them in, correct?
I want to move them in. I don't know if this is the appropriate time or if I'm supposed to do something else.
So I'm just scrolling through them briefly. Now is the appropriate time. Now it's fine.
Okay, I would like to move AHOBA exhibits 1 through 33 into evidence.
Thank you.
Okay.
So moved.
Your Honor, just for the pre-authenticated hearing exhibits, I know that they have been identified for purposes of authenticity and veracity for purposes of the pre-hearing order 22696. For the sake of clarity here, Washington Gas does not object to the admission of the list of authenticated documents not otherwise identified as cross-examination exhibits, subject to our ability to make appropriate arguments with respect to those documents on brief. And that applies for AOBA as well as any other party that did the same.
That's fully appropriate, and the commission will also determine the appropriate way to give said exhibits.
All I have, Your Honor.
For this witness. Okay. Any redirect?
Ms. Quinum, one question for you. Are the cost of the services provided by Washington Gas to its affiliates included in the revenue requirement at issue in this case?
No.
Ms. Quinlan, thank you for your testimony thus far. There are hundreds of entries in terms of, services that provided and cost going back and forth. How does Washington Gas ensure that any affiliate transaction cost allocated to its affiliates are fair and consistent with market prices?
I'd like to read Section 3 of that's the confidential version of the CAM, which contain confidential information.
Mr. Chairman, then I'll hold the question if this requires a response that has been deemed confidential.
The CAM, yes. I wanted to read Section 3, which is marked as confidential.
Okay.
If it's not a problem, I'll withdraw the question.
Okay. All right. Thank you. At this time, the commission moves PSC exhibits 44, 47, and 49 into the evidentiary record. Thank you. You're done. Next, we'll call witness block.
DCG would like to note for the commission that it does not have further cross-examination for witness Murphy.
Thank you.
I think I'm the only one on the cross-examine matrix for witness Block and witness Barronbrook. I don't have any questions for either one of those witnesses.
Okay. So, so let me just do, Mr. Block, why don't you have a stand in a seat in the audience for a second? Let me just make sure I'm tracking everything that was just said here. So there are no questions for witness Block, and there are no questions for witness Baron Bruck. Did I say that correctly?
I had them on in case witness Quenum referred a question to them. I wanted to be able to ask it, but I don't need to.
Okay. And DC government no longer has questions for witness Murphy.
Yes.
Okay. So at this time, that's all the witnesses that would be sponsored by Washington Gas. Okay. I just want to do a verification of the parties to make sure we're all on the same page.
Chairman Thompson, yes, that's also correct as to witness Murphy
Okay.
for Sierra Club. But one other matter, if we could just, similar to what Aoba just raised about admitting exhibits into the record, just wanted along the same lines, Sierra Club presented certain exhibits today, but did submit a list and submitted the list and upload the exhibits to the record yesterday. And to the extent that it is required, Sierra Club would move to have Sierra Club's Exhibit 1 through 28 admitted to the record, subject to any objection.
Same reservation that I made with respect to the other parties' exhibits, Your Honor.
Okay. Anybody else?
DCG would like to make the same request with respect to the exhibit list submitted.
Same with OPC.
This is just a logistical point. OPC witness Fitzhenry, I don't know if there are any questions for him, but he does have a scheduling conflict at about 6 Eastern. So I don't know if the commission wants him to appear
All right,
live.
well, I tell you what, hold on one second. Let me finish the pending motion with the exhibits.
Yep.
So moved as to the request by Sierra Club and DC government. I don't know if OPC has any.
Yes, my assumption was when WGL counsel spoke, he was agreeing to the admission of OPC 1 through 164 that was filed yesterday and listed on July 29. We would want to move that into evidence.
Okay.
Subject to the same reservation, Your Honor.
Okay. Thank you. And also at this time, Public Service Commission would move into the evidentiary record exhibits 26, 42, 46 through 48, and then 25 through 48. I'm going to come back to the Fitzhenry question in a moment. Just give me a second here. I want to make sure I'm covering all my bases. Okay. So WGL, do you have any, I believe you said earlier you do not have any questions for witness Fitzhenry. Is that correct?
That is correct, Your Honor.
Okay. And I anticipate or imagine that none of the other parties have questions for witness. Okay. So yes, witness Fitzhenry can be excused.
Okay, thank you. Appreciate that.
Thank you. We are now going to move to OPC witness Ostrander.
Yes, very good. Just give me 1 minute here.
Good afternoon, sir.
Good afternoon.
Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth, sir?
I do.
Thank you.
Please proceed.
Good afternoon, Mr. Ostrander. My name is Garrett Lint. I'm an attorney representing Washington Gas Light Company in this matter. Are you able to hear me right now?
Yes, I can.
Do you have a copy of your written direct testimony with you today, which has been previously marked and identified as exhibit number OPC-A or B,
Yes.
excuse me?
Yes.
Could you turn to page 26 of your direct testimony, lines 9 to 16? Let me know when you were there.
Okay.
You would agree with me that there is a tax sharing agreement in place between Washington Gas and various of its affiliates, correct?
Yes.
Would you also agree with me that this agreement allows Washington Gas's affiliates to use a net operating loss carry forward tax benefits of Washington Gas for purposes of a consolidated income tax return?
Yes.
Would you also agree with me that in return for Washington Gas's affiliates making a payment to Washington Gas for those benefits from using Washington Gas's NOLC on its tax return as well?
I'm sorry, could you repeat that?
Certainly. Would you agree with me that in return for the use of the NOLC benefits, Washington Gas's affiliates make a payment to the company for the benefits of using that NOLC on the consolidated tax return?
Yes.
And in this proceeding, did Washington Gas reduce its rate base by the amount of this payment?
No, they propose an adjustment to increase rate base.
Does Washington Gas utilize a normalization method of accounting as described under Internal Revenue Code Section 168, Roman numerat 19?
Yes, but that's not unique to Washington Gas Light. Virtually every utility that uses accelerated tax depreciation also uses and relies on that same code. So it's not a unique factor for WGL, and it doesn't distinguish them or make them unique or similar to the three private letter ruling affiliate companies, just from the standpoint that that's applicable to everybody in the industry.
Coming back to my question, however, Washington Gas does utilize a normalization method of accounting, correct?
Objection, he does not have anything other than WGL's own testimony to verify that.
I mean, to the extent he knows, and he can state what to the extent he knows and what he's basing that testimony on.
Yes, I can't say definitively that WGL is compliant with Section 168 all the time, because we sit here in this hearing right now addressing the situation that they are non-compliant with Section 168 from the standpoint that they're faced with potential tax normalization violation regarding their tax sharing arrangement with affiliates.
Are you aware of whether Washington Gas currently has a net operating loss?
Again, Your Honor, he doesn't have any direct facts, only what WGL has stated in this case. They're asking fact questions of an expert witness who's relying on what's written in WGL's testimony.
Your Honor, if I may, we provided the consolidated 2023 federal tax return. This witness had access to that return. I'm testing to see if he has knowledge as to what was claimed on that return.
Again, I mean, this is an expert who bases opinions upon the record in this case. To the extent he has the answer to this question, he can state that and what he's forming his opinion on.
I don't recall whether that tax return showed a taxable loss or not.
Do you have any basis in the record that you have reviewed to determine that Washington Gas does not have a net operating loss?
A net operating loss or a net taxable loss? That's two different issues.
Net operating loss specifically?
No, I don't believe WGL has a net operating loss on its books.
Could you turn to page 27 of your direct testimony, lines 7 to 8? Let me know when you're there.
Okay.
Fair to say on these lines, you reference IRS Revenue Procedure 2017-47 and Revenue Procedure 2020-39, correct?
Correct.
These procedures address safe harbor relief for inadvertent normalization violations, correct?
Yes, that's one of the primary issues they address.
They require a taxpayer utility to correct a inadvertent normalization violation at the next available opportunity, correct?
I believe, yes, that's one of the provisions.
In your opinion, would that generally be the base rate proceeding immediately following the filing of a federal income tax return?
I'm sorry, could you repeat that?
In your opinion, would the next available opportunity be the base rate proceeding that comes after the federal income tax return is filed identifying a normalization violation?
Objection to the extent it's calling for a legal conclusion, to the extent witness Ostrander knows through his regulatory experience. I have no objection.
I'm fine having the witness limit this to his regulatory experience. He does cite these revenue procedures, and he does claim to have experience with respect to the interpretation and application of PLRs. So if he has the basis under his regulatory experience to answer my question, that will suffice.
Please, yes, go ahead, witness Ostrander.
Very good. I don't know that necessarily the next available opportunity or rate case always follows a company filing its most recent tax return, because I think there's potential companies out there yet who have not filed rate cases yet and could be moving towards a second taxable year after they've had this potential tax normalization violation.
And in your understanding of the two revenue procedures we have been discussing, if a taxpayer does not correct that normalization violation at the next available opportunity, does an inadvertent violation become an intentional violation?
Objection to the extent it calls for a legal conclusion, to the extent he's asking for his regulatory experience. That's fine.
I am fine limiting my question in that fashion.
I'm actually going to overrule it outside of the scope of the material issue of fact and dispute. It's supposed to be about whether or not the facts of the letter are comparable to the facts with respect to WGL and not about the preferred method of recovery.
Certainly. For purposes of this case, Mr. Ostrander, is it your understanding that there are 3 private letter rulings or PLRs that Washington Gas witness Bale has reviewed?
Yes, they've only reviewed those 3 PLRs to the best of my knowledge, and those are all subject to just one holding companies because those are affiliate companies.
In your direct testimony, would it be fair to say that you discussed this NOLC and PLR issue from pages 24 to 35?
Your Honor, the testimony speaks for itself.
We've been proceeding this manner all day. He can speak to what his testimony says.
Yes, that's correct.
In that portion of your direct testimony, can you point me to a specific page or line where you discuss the facts and circumstances presented in the 3 PLRs identified by company witness Bale?
It wasn't necessary to address them in direct because the company provided very little information in their direct testimony, and I needed to wait on substantive data request responses from WGL before I formed a final opinion. And my final position and recommendation is in my surrebuttal testimony and not in my direct testimony. So it'd be more appropriate to rely on my position in my surrebuttal testimony where I address these issues.
I understand that. I just want to confirm where the facts are here. So would you also agree with me that within pages 24 to 35, you do not conduct a comparison of the facts and circumstances presented in the 3 PLRs to the facts and circumstances presented by Washington Gas.
This is asked and answered.
Sustained.
You have a copy of your rebuttal testimony with you here today?
Yes.
And is that the document that has been marked and identified as Exhibit OPC 2B?
Yes.
Give me one moment while I flip the number of pages that I have in front of me. Or indulge. You turn to page 39 of your rebuttal testimony. Let me know when you are there.
Okay.
On page 39, starting with line 3, you state, I now believe that WGL's actions regarding its tax sharing agreements have created a potential tax normalization violation. Did I read that correctly?
Yes.
And that is based upon your analysis of the facts and circumstances that you were able to review at the time you prepared your rebuttal testimony.
Yes.
At the time you prepared your rebuttal testimony, was it true that Washington Gas is a member of a group of corporations that file a consolidated federal corporate income tax return?
I'm sorry, could you repeat that question?
At the time you prepared your testimony, was it true that Washington Gas is a member of a group of corporations that file a consolidated federal corporate income tax return?
Yes.
At the time you prepared your rebuttal testimony, was it true that Washington Gas and the other members of that consolidated federal income tax group are parties to a tax sharing agreement?
Yes, although that tax sharing agreement has, the terms of it have changed over time. And no, Washington Gas Light has not prepared a comparison of the terms of the tax sharing agreement of its own to the specific tax sharing agreement of the 3 PLR companies.
The time you prepared your rebuttal testimony, was it true that Washington Gas had incurred a net operating loss for federal income tax purposes as the result of an accelerated tax depreciation deduction?
Objection. It's calling for a legal conclusion and has nothing to do with the scope of issue set in this case as to whether WGL's facts are similar to the PLRs at issue.
This is specifically one of the facts that was the subject of the analysis in the PLRs. I'm testing whether the witness was aware at the time of their rebuttal testimony as to what this fact was.
I'll allow the question.
As I stated earlier, I think I can answer that. As I stated earlier, I'm not sure if they had a taxable net loss for the most recent period, such as fiscal year in 2024. But they do have an NOLC on their books, a net NOLC on their books.
At the time you prepared your rebuttal testimony, was it true that Washington Gas accounts for the taxes it is able to defer as a result of accelerated tax depreciation deductions in excess of its book depreciation expense as a deferred tax liability?
Objection as to he can only rely on what WGL has provided. He has no specific direct facts of WGL.
Your Honor, this was proposed as a material issue of fact in dispute. If OPC is conceding at this point that this witness is unable to dispute the facts presented by Washington Gas witness Bale as to the items I'm asking about, I am happy to move along in my questions.
That is not the statement that I've made. I am stating that they're asking him to verify facts about WGL's business that he can only speak to based on the presentations made by WGL. To the extent that that is an understood qualification of his response, then I will have no objection.
And that's certainly the case. In order for him to give his opinion, he has to review the documents from Washington Gas, but we will certainly take note that his opinion and his fact finding is based upon information provided by Washington Gas.
Mr. Ostrander, would you like me to repeat that question?
No, I think I have it. First of all, just because WGL and the three PLR affiliate companies each have an NOL, that by itself is not indicative that they are in identical situations. And also, just because a company has an NOL, that does not mean they have a tax normalization violation. So the fact that two companies have an NOL does not mean that they are identical or the same in any respect. That's not a factor to rely upon.
At the time you prepared your surrebuttal testimony, was it true that under the terms of the applicable tax sharing agreement, Washington Gas had received tax sharing payments?
Could you repeat that?
At the time you prepared your surrebuttal testimony, is it true that under the terms of the applicable tax sharing agreement, Washington Gas had received tax sharing payments?
You know, that's a good question that you raised there. Because if they are still receiving tax sharing benefit payments from their affiliates, as of the time I was writing testimony and as of this date, they continue to march forward on an approach that is in violation of Section 168 and is a potential tax normalization violation. So I would certainly hope that they would have stopped the approach with tax sharing benefits provided to affiliates and receiving reimbursement, because that's just continuing the problems that created all of this and created this potential tax normalization violation. So I believe you do raise a very interesting question there of whether the company, despite what it knows, continues to take proactive actions in violation of Section 168 and further leading to a tax normalization violation.
I understand you may think this is an interesting question. I'm asking you, do you know that to be the case or not?
Your Honor, this is asked and answered and now argumentative.
He actually didn't answer the question. He said it was an interesting question and told us why it was an interesting question, but he didn't actually answer the question. So to the extent that you know, please answer.
Yes, I do not know as of the recent date if they are still continuing their improper actions that are in violation of Code Section 168 regarding the tax sharing payments. I know that I asked for detailed information regarding the tax sharing payments, or OPC asked for detailed information regarding the tax sharing payments to try and reconcile it to the $26.4 million of NOLC that they're proposing as a rate base adjustment, but none of the responses provided that reconciliation. Therefore, it makes it difficult for me to determine the amount of the individual tax sharing payments received for each year when a reconciliation was not provided for those amounts.
So coming back to my question, you don't know whether that was the case or not.
I do not know whether they are continuing the tax sharing payments.
Because you do not know that, you would not have addressed it in your testimony, would you?
Your Honor,
I did address.
Sorry.
I
So-
did address it from the standpoint that I indicated I was unable to reconcile the 26.4 million NOLC adjustment to actual tax payments that WGL had received.
I'll move on from that answer. At the time you prepared your surrebuttal testimony, were you aware of whether or not prior to 2024, Washington Gas had accounted for the tax sharing payments it received by debiting cash and crediting its NOL DTA?
I believe in a data request asked along those lines, they indicate that the adjustment that they make on their GAAP books is a reduction to the NOL or DTA. And I believe that they currently, on their regulatory books, make an adjustment debiting cash for receipt of the tax sharing payments from other affiliates, and they credit retained earnings, which acts to increase retained earnings.
And at the time of you prepared your surrebuttal testimony, were you aware of whether or not, for rate-making purposes, Washington Gas had reduced its rate base by its DTL and increased its rate base by its NOL DTA?
Could you repeat that again?
At the time you prepared your surrebuttal testimony, were you aware that previously, for rate-making purposes, Washington Gas reduced its rate base by its DTL and increased rate base by its NOL DTA?
It's my understanding that in this case, they propose to increase rate base by the DTA or NOL by 26.4 million, if that's informative of your question.
That proposal was made after they had identified the inadvertent normalization violation in the 2023 consolidated federal income tax return, was it not?
I don't know if they identified it in their tax return. I know that the company identified this concern at one point in time, but I don't know the genesis of the specific time when they identified this problem.
You had reviewed the testimony prepared by company witness Bell as a part of this proceeding, correct?
Yes.
Are you aware of company witness Bell's testimony that the company had self-reported the inadvertent normalization violation on its 2023 consolidated income tax return?
That sounds familiar. I don't recall if it was from testimony or from a data request response.
Do you have any reason to dispute that statement?
I don't know if I have a problem or any problem or any information to dispute that.
One moment, I'm checking my notes, Your Honor. No further questions.
I do have one question. Witness Ostrander, when you were talking, you said that if Washington Gas was continuing the tax sharing agreement, they would be in violation of the NLLC DTA. I believe is that what you said?
Yes, and I probably should have said potential violation. My testimony states that I don't think we can affirmatively say that they have a tax normalization violation until a private letter ruling is issued and the IRS comes back with that determination.
Okay. That's where I was going. Thank you. This is OPC's witness. Any redirect for the witness? Okay. Thank you, witness Ostrander.
Thank you all.
Witness Andrews, who will also be remote.
Good afternoon.
Good afternoon, sir. Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth?
Yes, I do.
Thank you.
Good afternoon, Mr. Andrews. My name is Garrett Lint. I'm an attorney for Washington Gas Light Company. Are you able to hear me okay?
I am, yes. Good afternoon.
Do you have a copy of your written direct testimony from this case with you?
Yes, I do.
And has that been previously marked and identified as exhibit number OPCE?
Yes, that's correct.
Could you turn to page 34 of your direct testimony? Let me know when you were there.
I'm there.
Lines 1 to 3 of page 34, you set forth your recommended adjustment with respect to account 3676.20 plastic mains. Is that correct?
Yes, it is.
That adjustment is based upon an increase in the average service life of assets in this account. Is that correct?
Yeah, yes, that's correct. The $3.2 million reduction is based on my adjustment to increase the average service life from 55 years to 67 years.
And on lines 8 to 10 of this same page, you set forth your recommendation with respect to account 38.20 plastic services. Is that correct?
Yes, sir, that's correct.
And the adjustment you recommend, again, is based upon an increase in the average service life for that account.
Yes, for this account, the $2.2 million adjustment is based on increasing the average service life from 55 years to 65 years.
If you could repeat yourself, Mr. Andrews, you kind of came through a little muffled.
Oh, I'm sorry about that. The $2.2 million reduction I discussed there at lines 8 to 10 is based on my recommended adjustment to increase the service life from 55 years to 65 years.
And just so that we're clear here about revenue requirement impacts of your adjustment, the two adjustments that you recommend when combined with Dr. White's reserve allocation procedure would reduce Washington Gas's annualized depreciation accrual by $6.13 million and have impacts upon the composite depreciation rate proposed, correct?
Yes, that's correct.
Could you turn to page 1 of your direct testimony with reference to lines 15 to 19? Let me know when you were there.
Yes, I'm there.
Excuse me, page 2, lines 15 to 19. I apologize. You know when you're there.
Yes, I'm there.
Your testimony is based upon your assessment of Washington Gas Light Company's proposed depreciation study. Is that correct?
Yes, that's correct.
You provide your assessment of Washington Gas's depreciation study, correct?
Yes, I do.
You did not independently prepare your own depreciation study in this matter?
No, I did not conduct my own depreciation study. I reviewed the depreciation study filed by Washington Gas along with all of the work papers that were provided along with that depreciation study, and I conducted an analysis to determine what I felt was the most reasonable life recommendation for Washington Gas's two largest accounts.
And as a part of that assessment, you did not independently gather the property data relied upon to present your direct testimony, did you?
No, sir, that was provided by Washington Gas to Dr. White, who then provided it to OPC for the two accounts that was studied.
You did not independently code this data either?
No, I did not.
You did not undertake any attempt to reconcile the data collected to prepare your testimony?
No, I did not audit all of the data.
Did you review and analyze Washington Gas's actual property records as a part of the preparation of your direct testimony?
To the extent that that data was provided to me, we did review it. I did review it. The continuing property record data that was provided for all accounts, I looked at that, attempted to create the original life table data that Dr. White performed his analysis on. But the life analysis that I have provided that support my exhibits, those were provided directly from Dr. White.
So would it also be fair to say that you did not conduct interviews with WGL personnel as a part of the preparation of your direct testimony?
I did not.
You, and I think you mentioned this, I just want to be clear, you relied upon the property data gathered by Foster Associates?
That's correct.
And just to confirm, you didn't develop your own observed life tables for Washington Gas Light's plant accounts in this case, did you?
I did not. No, I relied on the same life table data that Dr. White provided to us.
You did not undertake an analysis to graduate hazard rates?
No, I did not. That is not uncommon.
You did not conduct a weighted regression analysis of any sort?
No, that is not a common procedure in conducting a depreciation study.
And you did not conduct a banding analysis of any sort, did you?
No, I did not. I relied on the original life table that encompassed all of Washington Gas's data, which was property that was installed from, I believe, 1958 until 2023 for experience that occurred between 1986 and 2023.
You have a copy of your written rebuttal testimony with you, correct?
Yes, sir, I do.
And that has been previously marked and identified as Exhibit OPC number 3E. Is that right?
I have 2E on the version I'm looking at.
Did he say? Could you repeat that, Mr. Andrews? Sorry, we didn't hear you here.
I have 2E on the version that I'm looking at under the conformed copy that was filed on July 25th.
I apologize. I may not have the conformed in front of me here. Subject to check, though, you have what is before you, the rebuttal testimony you prepared in this case, correct?
Yes.
And could you turn to page 4 of that rebuttal testimony, lines 14 to 15, sentence starting with the final decision. Let me know when you are there.
I'm there.
You're discussing the use of informed human judgment at these lines, correct?
Correct.
And informed judgment takes into account all relevant factors and information that may be considered by the depreciation professional.
Yes, I would agree with that.
Information gathered from discussions with utility personnel would be a relevant factor to take into account for the application of informed judgment, would it not?
Yes, that would be one relevant factor.
Would physical observation of plant itself also be a relevant factor?
It could be, but the plant that I have recommended adjusting the service life for its plant is buried underground. So seeing that equipment would not be possible.
Mr. Andrew, can you just make sure you keep your voice up? You're going in and out here. Thank you.
I apologize for that. So my answer was the two accounts to which I've recommended an adjustment to, accounts 376.2 and 380.2, are the mains and services accounts. Both of those accounts are for equipment that is buried underground, therefore an inspection would not be possible.
No further questions, Your Honors.
Thank you. Any redirect?
No redirect. Thank you.
Okay. Any other party would like to ask Mr. Andrews any questions? Okay. Thank you, Mr. Andrews. You are excused.
All right, thank you.
Just going to verify there are no other witnesses.
No other witnesses for the company to cross, and I believe we have gone through all of the witnesses that were designated for presentation, Your Honor.
Okay. I see nodding heads. For the record, can we just get an affirmative answer? Thank you.
Correct.
Thank you.
Yes.
Thank you. At this time, the commission marks several exhibits that it wishes to place on the evidentiary record that are sponsored by witnesses that are not testifying. These exhibits are contained in the matrix that was provided to parties on August 13, 2025, and include PSC exhibits 7 through 21, 29 and 30, and 50 and 51. The commission admits these exhibits into the hearing record at this time, so all PSC exhibits 1 through 52 are on the evidentiary record. We have a few closing matters here. There is one outstanding bench request that must be submitted to the commission by close of business on August 21st, 2025. Motions to correct the transcript and the final corrected list on the cross-examination exhibits are due by August 27th, 2025. Briefs are due September 4th, 2025. There will be no reply briefs. And with that, the record.
When you're done, could I? During the break, I asked the parties and Washington Gas if we could get an extension for all parties from Wednesday, September 4th. No, I think it's from September 4th through September 10th for the briefs. Counsel and its witness are scheduled to be in Richmond starting September 2nd that week at Virginia Power hearings. I don't like to let anything out of my office without me working on it. So if all parties could have an extension. Washington Gas did not have time to get back to me with a response because I just asked him during the lunch break.
No, we are fine with that request, Your Honor.
Okay. We are fine as well, and I understand wanting to see it come out of the office, so
Thank
no
you.
problem there. Another matter, I just want to, on behalf of my fellow commissioners, just want to thank everybody for their cooperation here today and patience getting through this. I don't know if there's any concluding remarks either commissioner would like to give.
Not other than thank you for your patience and your time.
And there being no further matters, this hearing is adjourned. Thank you.